Good morning. My name is Adrienne Roberts Larson. I'm the Chief Deputy for the Department of Taxation. I'd like to call this meeting of the State Board of Equalization to order. Today is July 29th, 2026 in Las Vegas, Nevada, and the time is 9 a.m. This is the time and place as scheduled. This meeting has been properly noticed in compliance with the Nevada Open Meeting Law. Joining me in the Las Vegas meeting location are department staff, including Carrie Skowski, who is our Management Analyst 3, and Denise Mosley, Program Officer 2. Denise, would you please call the roll?
Good morning. This is Denise Mosley for the record to take roll. Chairman Bancroft.
Here.
Member Burke.
Here.
Member Cadwell.
Here.
Member Orrock. We have a quorum, Chairman.
I apologize for being the last one to arrive today. My name is Paul Bancroft. I'm the chair of the State Board of Equalization. On my left, immediate left, is Curtis Cadwell, and next to him is Kevin Orrock, both members of the State Board of Equalization, and attending via the Zoom link is Corinne Burke, the other member of the state board. We only have 4 members. We could have a 5th, but the governor hasn't appointed one yet. Public comment. Denise, could you read the public comment language?
Yes. Good morning. This is Denise Mosley for the record. Persons wishing to provide public comment remotely may access the meeting by using the telephone numbers and meeting ID posted on the agenda. Public comment will be limited to 3 minutes per person, and comments based on viewpoint will not be restricted. Public comment will be available at the beginning of the meeting and at the end of the agenda. At the discretion of the chairman, additional public comment may be heard when that item is reached. The chairman may allow additional time to be given to a speaker as time allows at his sole discretion. NRS 241.020, NRS 241.030. Is there anyone in Las Vegas who would like to make public comment? Is there anyone on Zoom? If there is anyone on Zoom, please raise your hand. And if there is anyone on the phone that would like to make public comment, please dial *9 and you will be placed in the queue. We do have public comment. Chairman, just one second. Mr. Bunton, I have allowed you to speak. Please go ahead. Mr. Bunton, can you hear us? Go ahead, Mr. Bunton, for public comment. Mr. Bunton, can you hear us? Please go ahead for public comment. Mr. Bunton, we cannot hear you. If you could please come back at the end of the meeting for public comment, or you may also email it in. Thank you, Chair. We do not have any other public comment.
What was the problem with?
He was unmuted. I don't believe he could hear it. Mr. Bunton, are you there? Yeah. We cannot hear him, and he no longer has his hand raised either.
I'm,
Mr. Bunton, are you there? We cannot hear him, Chair.
um, do you have a telephone number for Mr. Button?
We do.
Can you call him and see if you can work out a way for him to make a public comment?
Sure.
We'll wait for this.
Okay, Mr. Benson, go ahead with your public comment.
Yeah, the only comment I had was that I prefer to have the hearing at where I live and Reno or Carson City, and I was told that I was possible. So I was unable to attend this meeting today in Las Vegas. That's all I had to say.
Okay. Thank you, Mr. Benson.
Yeah.
Chief Deputy Roberts Larson, would you read the rules of the hearing and administer the oath to those testifying today?
Yes, thank you, Chair. Again, this is Adrienne Roberts Larson for the record. Pursuant to NAC 361.686 subsection 3, a person appearing in a proceeding shall conform to the recognized standards of ethical and courteous conduct. The State Board of Equalization recognizes the following rules for hearings. Do not speak unless you have the permission of the chair. When the chair gives you permission to speak, speak only to the members of the State Board and not to anyone else. Do not talk when members of the State Board are talking, and do not interrupt anyone. Do not speak, make noise, or gesture with your body when someone else is speaking. Do not argue with the chair, State Board members, or the parties to the hearing. Do not speak down, demean, or harass anyone in the proceeding or in the meeting. Do not raise your voice or act in a hostile or aggressive manner. If you want to move from behind the table, ask the chair for permission to do so. Handouts such as evidence must be handed to the State Board coordinator for delivery to the State Board members. I would also like to add that each time you speak today, please speak clearly and not over one another, as we do have a court reporter attending on Zoom that is transcribing the proceedings. Please identify yourself each time you speak. We do acknowledge this can be a little bit awkward, but as the conversation moves back and forth between yourself and the board or the chair, please make sure that you again state your name for the record. For those testifying today, would you please stand and raise your right hand to take the oath? Do you hereby swear that your testimony during these proceedings will be truthful? If so, say I do. You may be seated. Agenda item 4 is provided as a consent agenda item for possible action on the 2026-2027 secured roll and the 2025-2026 unsecured roll. State Board case number 26115 relates to residential property located at 223 Sunglaze Avenue, Henderson, Nevada, Clark County, APN 160-15-514-006. Property owner Stephen Bunton filed this petition with the State Board of Equalization from action of the County Board of Equalization for tax year 2026-2027, secured roll pursuant to NRS 361.360 and NRS 361.400. The petitioner and respondent in the case have agreed to resolve their respective matters as reflected in the proposed stipulation included with the meeting materials. Mr. Chair.
this case, Desert Hair, has a pending stipulation for our review and approval. But I'd like to take it off the consent agenda and make a few comments regarding the case. And then if Mr. Button or Mary Ann Weidner would like to comment, I'd ask them to do so. There are 4 comments I'd like to make concerning this case. First, the form of notice that's utilized by Clark County states, quote, "Your hearing date has been set. It cannot be changed." That statement is not correct. The rules governing hearings before the state board allow parties to request a continuance. These same rules apply to the practice before the county boards. Consequently, the blanket statement that the hearing date cannot be changed is inappropriate. Second, in this case, the petitioner informed the assessor's office that because of travel plans, he would not be able to attend a hearing after February 13th. Petitioners are entitled to a fundamentally fair procedure, which in this case required consideration of his scheduling request. Here, there is no indication his request was considered. I understand the county board held hearings on February 5, February 9, and February 11. The county board could have considered his request, and his scheduling request could have been granted. 3, the board is required to hear each complaint brought before it. Here, the county board did not call the petitioner. It does not appear that the county board called the petitioner's case or reviewed the evidence. It simply made a blanket motion to accept the assessor's recommendation on all cases where the petitioner stipulated to the result, withdrew their petition, or did not appear. It was inappropriate for the county board to resolve the petitioner's case without calling the case and reviewing the evidence. And finally, there was sufficient evidence presented by the petitioner to call into question the taxable value the property was being assigned. The petitioner acquired the property in 2024 for $535,000. The assessor stipulated the taxable value of the property for tax year 2025-26 was $535,000. The assessor proposed almost an 11% increase for tax year 2026-27. The assessor identified 10 properties it considered comparable. For half of those properties, the taxable value that's been assigned is less than it was assigned for tax year 2025-26. The average increase in taxable value for the 10 properties was less than 1%. Consequently, I can understand petitioners' concern over an 11% increase in their taxable value. Furthermore, 6 out of 10 of the comparable properties are assigned taxable values which are less than the property's sales price. The average taxable value is 93.7% of the property's sales price. Here, the proposed taxable value of petitioner's property was almost 111% of the property sales price. Again, this supports the petitioner's concern. These comments regarding the evidence in the record does not mean he would have prevailed had he gone to hearing, but there was sufficient evidence in the record for the county board to consider the case and make a reasoned decision. Those are my comments. Would you see if Mr. Button would like to make any comments?
Mr. Button, would you like to make any comments? Mr. Bunton? He has not raised his hand, Chairman.
I should have asked first, do any of the other board members have comments regarding this case?
No, Chair.
Terry, are you checking with Mr. Button?
For the record, this is Carrie Skalsky. Mr. Bunton, I see that you are on Zoom and you also have dialed in. If you would like to speak from your telephone, please unmute yourself using *6.
Can you hear me now?
Please
Here,
mute
let me
your
see if I
Zoom.
can. See if I can't get rid of both of this here. Thanks for telling me about this. Okay.
If-
I would just.
I'm sorry,
I
Mr.
appreciate
Bunton.
the.
We have
I
some
appreciate
feedback.
the chairman's comments. This has been a long process.
This
And
is the court reporter. This is
I would just assume
Mr.
to go with the
Bunton.
stipulated value.
Mr. Bunton,
Yes.
if you could please mute your audio on your laptop and just use your telephone. We're getting a lot of feedback.
I'm trying.
You may want to dial in again, Mr. Bunton.
Okay, can you hear me now?
Yes, that's much better. Thank you.
Okay, I just got out of the meeting entirely on Zoom. That's the only way I could do this. Again, I apologize for all of this. Just I didn't understand how all this technology worked. This has been a long, arduous process, and the county assessor, supervisor of the assessor that I was working with, apparently agreed with the approach here, and she went back and did a paired analysis, which I believe is actually looking at homes that sold as I put in my original appeal, and they came to the conclusion that they could reduce the valuation. It's not what I asked for, but at this point, obviously, given the fact that there's time and effort and expense to travel to Las Vegas to deal with this, I would just assume that I would just would rather just go ahead and go with the stipulated value that they've changed this to at $570,000. I do appreciate very much the chairman's comments and his concern about how this whole procedure went. But at this point, I think it would probably be in everybody's best interest and in the interest of everybody's time just to move forward with the recommendation, which I signed off on June 15th.
Thank you, Mr. Bunton.
You're welcome.
Ms. Widener?
Can you hear me? Okay. Yes, Mr. Bancroft, I will tell you that I took a look at this case. And after the board hearing, when the gentleman had appealed to the state board, because I wanted to make sure we had addressed everything appropriately, which we do with every single one of our cases before we come to the state board. And I myself felt like we had possibly missed something. And I did the paired salads analysis myself to determine what an appropriate value would be. We did provide that to the petitioner, and that is why the recommendation for the reduction was made. With regards to him missing the meeting, I don't know all the conversations because unfortunately I don't get to talk to every single petitioner that files. I think some of those conversations may have been had with some of our management staff. All I know is by the time we understood that he couldn't attend any of the rest of the meetings. And so by the time I understood that, and so there was no other meetings that we could schedule him for because all of our meetings have to be concluded by the end of February. So we understand your concern, and we are still in support of the stipulation. We feel like it's a good value. We feel like if you were to see all the information, you would support that as well as the county board. And we think it's reasonable given the current market conditions that are in the market. We think that there has been increases in sales since the prior year value. And so if he was to have sold it for this particular fiscal year, we think he would have probably gotten a better price for his property. So those are my comments, and willing to listen to everything you have to say.
Thank you. Would someone like to make a motion to approve the proposed stipulation?
Curtis Cadwell, for the record, I'll make a motion to approve the stipulation.
Is there a second?
Kevin Orr, for the record, I'll move the second.
All in favor, say aye.
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 The vote was unanimous. Thank you.
Mr. Chair, are you ready to move on to agenda item?
Yes,
5?
would you please introduce the next?
Yes. Adrian Roberts Larson for the record. Before I go on to agenda item 5, wanted to mention one more matter of housekeeping. As you notice, for the microphones that are in front of you here today, in order to have a clear record for the court reporter, there's a very narrow cone when you are speaking into those microphones. So for both the members and for those of you speaking that are attending here today, you'll want to make sure that the mic is directly in front of you as close as possible so we can pick up what you're saying. Also going forward, starting at this point, as I said earlier in the meeting, please state your name each time that you speak as we volley back and forth. If you do not, you will hear my voice repeatedly today as I will be interrupting you and reminding you to state your name. So moving on to agenda item 5. This is provided as an agenda item for possible action on the 2026-2027 secured tax roll and the 2025-2026 unsecured roll. This item pertains to appeals filed with the State Board of Equalization from action of a County Board of Equalization pursuant to NRS 361.360 and NRS 361.400. The value of real or personal property is being appealed. The petitioner has agreed to the action of the county board or the failure of the county board to equalize, resulting in overvaluation of property or undervaluation or non-assessment of other property. State Board Case Number 26-107 relates to residential property located at 2709 Pinto Lane, Las Vegas, Nevada, Clark County, APN 139-32-703-002. Property owner Mark Wilson filed this petition on the Clark County Board of Equalization action for tax years 2026-2027 on the secured roll. Pursuant to NRS 361.360 subsection 2, all such appeals must be presented upon the same facts and evidence as were submitted to the County Board of Equalization in the first instance, unless there is discovered new evidence pertaining to the matter which could not, by due diligence, have been discovered before the final adjournment of the County Board of Equalization. The new evidence must be submitted in writing to the State Board and served upon the county assessor not less than 7 days before the hearing. The petitioner submitted new evidence on July 6, 2026 and July 16, 2026 for the State Board's consideration. Mr. Chair.
Thank you. Would you welcome back, Mr. Wolfson? I assume you will be representing Pinto Lane Trust, and who will be appearing on behalf of the assessor's office? Please speak up.
Jarrell Turner with the Clark County Assessor's Office.
Jamie Jacobs, Clark County Assessor's Office.
And Carla Pipitone for the Clark County Assessor's Office.
Mary Ann Widener, WEIDNER, with the Clark County Assessor's Office.
Before we address the new evidence which has been offered or the merits of this appeal, there's a preliminary matter we need to address. It's been alleged that there was a procedural irregularity that affected the fundamental fairness of the hearing before the County Board of Equalization. Specifically, I understand that portions of the assessor's evidence were entered into evidence, made available to board members, and were referred to by the assessor's office during their presentation of the case, but were not provided to Mr. Wolfson either before or during the hearing. I believe Mr. Wolfson referred to this as proceeding with one arm tied behind his back. If true, I think it's worse than that. We have to ensure the fundamental fairness of the hearing, and to do that requires that the parties share the evidence that's going to be presented to the tribunal. Mr. Wolfson, could you comment on this, please?
Mr. Wolfson, please state your name for the record. Thank you.
This is the court reporter. I cannot hear him.
Mr. Wolfson,
My best. So if everybody could do their best to speak loudly, I would appreciate that.
yes, and then we'll keep the microphone close to you,
Yeah.
and then remember that cone
And I
directly
will
in front
tend
of
to
it.
speak too loud because I can't hear myself sometimes.
Understand, the court reporter just was having difficulty hearing you at the moment.
Thank you. So to answer your question,
Yes, please confine your statements to this question of
Okay, yes.
was the hearing in front of the County Board of Equalization fair? Did it create an adequate record for appeal?
Absolutely not. At the hearing, as the standard practice, since it's the second year going, I was called to make my presentation after the county made their introductory information. And I made my presentation, and then it was their turn and they made their presentation. And during their presentation, Ms. Jacobs was referring to a couple of charts, which I absolutely could not find, so I couldn't follow along. And I interrupted them just to ask what page are you on and where can I find it? Could not find it. Finally, I just sort of like gave up and said, let's just proceed, something like that. After the hearing was over and they ruled against me, I sat and watched the only other case that was there because I was interested, because he was there last year as well. And I watched his case. And about approximately the middle of his case, one of the employees of the county, and I believe she's here today, I think I recognized her, came over to me and said, the reason why you couldn't find those charts is because we forgot to give you some of the documentation. Now, Ms. Widener, okay, then his hearing ended and Ms. Widener stood up and spoke to Mr. Farr, advising him that we forgot to give, or we neglected to give Mr. Wolfson a few pages. Those were her exact words, a few pages. Now, prior to the hearing,
Excuse me, Mr. Wolfson. Could you identify by SBE page numbers, which pages
yes, I can.
it is that were
Yes, I can.
omitted?
It's pages. Did I write them on this one? If you give me one second. You can start on page SBE 1012. You'll find that in the fourth tab on the case files,
Mhm.
noted 901 to 1129.
And then it continues to,
It goes to the end. Yeah. May I show you something? 1 week prior to the hearing, I had conversations and emails with Mr. Jarrell Turner of the assessor's office, and we made a scheduled a time to exchange documentation. I brought in my evidence, which was heavy, I grant you, And he handed me this, I think these are 8.5 by 17 pages. This was the evidence they gave me. This is 78 pages long. This is the document the young lady gave me after the hearing was, they're the same size. This is 78 pages and this is 71. This is what I did not have. This is the documents that Ms. Jacobs used in her efforts to basically eviscerate my presentation. I did not have this. I have it now, and I have gone through it now, and I am prepared to provide my rebuttal and my refutation, is that the right word, of the evidence that she presented and the errors that this includes, and the misleading and the material misleading information that was presented. I did not have that in time. If I had it in time, I would have been prepared to present the evidence I have today to present.
Thank you, Mr. Wolfson. Ms. Leitner, would you like to address this?
Yes, thank you, Chairman Bancroft. I will tell you during the county boards, I'm down in the front. I'm not in the back. We do have a staff in the back that checks everyone in. I have documents here that show Mr. Wolfson did check in. During that time when they check in, we have all of the documents available for them at the back. So when they check in, we give them the documents at that time. According to the staff that was there, they attempted to give him the documents for the addendum and he said he didn't need them. And so he did not take them at that time. When we got down to the hearing and the conversations were had that he could not find the reference materials, he interrupted multiple times during Ms. Jacobs' presentation. We stopped, we waited for him to find the pages. I had no indication from him that he could not see the materials. We would have stopped and made sure he had the materials. I would have gone back there myself and stood next to him to make sure that he was looking at what we were looking at. We always do this. We get up and we actually help the petitioners. We've done it multiple times. So we had no indication during the hearing that he did not have the materials that Ms. Jacobs was referencing throughout her presentation. And if you were to go back and look at the transcript or actually to watch the hearing, you'll see that we stopped for several minutes or multiple times to try to make sure that he was right where he needed to be. And I had no indication that he did not have those materials at that time. So it was only after the hearing that we realized that he had not picked up the materials, but they were available for him to pick up. The other thing that I just want to reference is there's nothing in statute that requires that we provide information to the petitioner in advance of the hearing. No different than there's nothing in statute that require the petitioners to provide anything in advance to us for the hearings. We try our best to work all the cases and review all the materials that the petitioners supplied. But I know you yourself know that many times people show up at the hearings and provide them information at the county board hearings. It's allowed by law. They're allowed to do that. And the assessor is also allowed to do that. We do our best to have it in advance. The things that we did have in advance, we did provide to him in advance. They can get it up to 3 days in advance. But anything that's an addendum to that, they get it the day of the hearing. And that's just the way it rolls. So we have a very tight time frame between the time somebody can file an appeal and we can actually get these appeals completed to get all this information put together in the case. And ultimately, NRS 361.345 says that the County Board of Equalization, they may not reduce the assessment of the county assessor unless it is established by a preponderance of the evidence that the valuation established by the county assessor exceeds the full cash value of the property or it is inequitable. We've done our job by valuing the property. It's really the petitioner's job to tell us what we've done wrong. And everything that Mr. Wolfson has brought forward, we've tried to address, but sometimes he continues to bring information and we continue to try to address it. And that's the reason for the addendum and the additional information. So it wasn't intentional that he was not allowed to have the information. I had no idea that he didn't have the information when the hearing was going on. If we had known, we would have gotten the packet and brought it down to him and given him time to review it. He could have sat down while we dealt with the other petitioner, and then he could have come back up at a later time and continued his case. But we weren't aware of that, and it wasn't till after all the hearings were completed that he came forward and he said what he said. I did open it up for the county board members to decide at that time if they wanted to go ahead and reopen the case based on him now having this information available to them. And the comments from the chair at that time says it wouldn't have changed his mind with regards to the hearing. I thought perhaps it was his information that wasn't included. I did not realize it was our information that hadn't been included. And the board wasn't sure what it was at that point in time. So I'm just trying to be transparent with you and explain to you exactly the events that I understand. Thank you.
Thank you. I can understand, Mr. Wolfson, approaching the hearing, thinking he has all the materials, not realizing there was a supplemental addendum that your office had prepared. So I can understand his thinking when he signed in that I've got all the materials. I don't need another set. And to your comment that, well, you can submit evidence at any point in time up to the hearing. I agree with that. You know, I totally understand. I've been there. I've done that. But whenever you do that, you make it apparent, you bring 10 copies, you let everybody know. This is evidence that hasn't been made part of the record. I'm bringing it here today to add it to the record. The addendum was not presented in that fashion at the hearing. So again, I can understand Mr. Wolfson's concern that he didn't have an adequate time to review that information and prepare a rebuttal to evidence presented in those 71 pages. So, you know,
May I comment on that, Mr. Chair? So
Please state your name for the record.
Mary Ann Widener
Thank you.
with the assessor's office. I believe, and I'm going to let Ms. Jacobs make a comment on that if that would be
no,
okay.
we're not taking multiple,
It's
it's
just,
your voice.
we did at the hearing say this information is in the addendum book. It was very clear on the record that we were looking at information in the addendum. So it wasn't a surprise that we were looking at an addendum. It was made, the comment was made on the record that we were looking at the addendum. We were referencing the addendum. We thought he had the addendum. So it wasn't a secret. So
No, I understand. I am not imputing to you any ill motive. It's just a coincidence, a series of unfortunate events, which has led to a situation where Mr. Wolfson feels he has not had a fair hearing. I'm not imputing to you any intention or ill motive. It's just an unfortunate series of events. I think there is in this case a serious question about whether the record on appeal in this case is inadequate because of an act or omission of the county assessor, the district attorney, or the county board of equalization. And there was confusion with regard to the new evidence and whether it was available to Mr. Wolfson, whether he had it or not. And when the issue came to light in front of the county board, instead of reopening the case, they dealt with it somewhat cavalierly. They did not look into it to see, well, which evidence was not provided to Mr. Wolfson, which evidence could he have had a chance to rebut if he had known about it. So I do think this creates a question under NRS 361.360 subsection 6 as to whether or not it should be remanded to the county board.
May I say something?
No. we have a representative from the Attorney General's office with us, Dana Cook. Could you please explain what NRS 361360 subsection 6 provides?
Yeah, I think the easiest, quickest way would be if I just read it.
Yeah,
Can you
Cook,
please
you
use your
identify yourself?
microphone?
Dana Cook for the record. Yes, Chair, I think the easiest way is if I just read subsection 6 of NRS 361.360 into the record. States, if the State Board of Equalization determines that the record of a case on appeal from the County Board of Equalization is inadequate because of an act or omission of the county assessor, the district attorney, or the County Board of Equalization, the State Board of Equalization may remand the case to the County Board of Equalization with directions to develop an adequate record within 30 days after the remand. The directions must indicate specifically the inadequacies to be remedied. If the State Board of Equalization determines that the record returned from the County Board of Equalization after remand is still inadequate, the State Board of Equalization may hold a hearing anew on the appellant's complaint, or it may, if necessary, contract with an appropriate person to hear the matter, develop an adequate record in the case, and submit recommendations to the State Board. The cost of the contract and all costs, including attorney fees to the state or the appellant necessary to remedy the inadequate record on appeal, are a charge against the county.
This case is it's very likely that this case is not going to end here at the State Board of Equalization. That regardless of how we rule, one party or the other will appeal it to the district court. I think that it is prudent for us to make sure we create the that we follow the law and that we create the best record possible for whoever is for the court to review. So I would be inclined to vote for a motion remanding the case to the county board to develop the record more fully, allow Mr. Wolfson the opportunity to present his rebuttal evidence, and then more likely than not, we will hear the case again. But do any of the other board members have thoughts on?
You're getting into a lot of legal stuff, Paul. I'll leave legal interpretation to you, but it makes sense.
Kevin Orrock, I agree with Curtis's comment.
Corey Burke, I also agree with the chairman and everyone's comments.
Mr. Chair, may I ask a question?
Can you please identify yourself?
This is Paul Bancroft. Mr. Wolfson, would you like to make a brief comment?
Just two questions from what everything been said.
Mr. Wolfson, identify yourself.
I'm sorry, Mark Wolfson. If you remanded back to the county, I referenced in my brief that Mr. Farr, and to be perfectly honest, the other two members of that board show a lack of knowledge in the areas that we are discussing, and Mr. Farr has an animus towards me in his cavalier attitude and the method in which he accepts everything that the county has to say and refuses to understand anything I have to say, particularly when he ended at the end. Even if you had the additional 71 pages, I wouldn't have changed my vote anyway, and you've done nothing here but grandstanding. I don't think he can provide a fair outlet for me. There is another option that Mr. Cook had referenced. It just, I could go on about what Ms. Widener said earlier, but I won't. The other question I have is, regardless of how this proceeds, can this board take a vote? I don't know. I didn't even know the proper methodology. Take a vote to accept into evidence all of the additional evidence I submitted that are in response to the documentation I was not given.
Okay, thank you for your comments. Ms. Widener?
I cannot speak for the
Ms.
board
Widener,
members, and as
identify
far as
yourself,
their
please.
Mary Ann Widener with the
Thank you.
Clark County Assessor's Office, forgive me. I cannot speak to the board members. I will tell you that Mr. Wolfson's hearing went for an hour and a half. He was allowed to speak for an hour and a half. And I think they tried to listen to what he had to say. I'm not in their heads. I just know the comments that they said on the record. I do feel Mr. Wolfson, if someone does not agree with him, he immediately thinks that they don't know what they're talking about. He's done that with our office. So, but we are willing to do whatever the board directs us to do. And if you would prefer to remand that, then that's what we will do. If you prefer to hear it today, we're willing to do that as well. Either way.
Thank you. Your question about admission of new evidence, I think that's a matter for the county board to hear if this case is remanded. In terms of, well, he had a hearing for an hour and a half, that's meaningless. I had a hearing in front of the Clark County Board of Equalization that lasted 2 days. So the length of the hearing is what's necessary to make it a fundamentally fair procedure. I'll make a motion that this case be remanded to the County Board of Equalization with directions to develop an adequate record, making specific findings of fact and conclusions of law that address Mr. Wolfson's arguments, including his main argument, which appears to be that his property has received a supplemental assessment for the renovation of his property, while other properties which have been renovated have not received supplemental assessments or have received supplemental assessments which do not capture the full extent of the renovation. The failure to capture the value of the renovation results in these properties having a lower Marshall Swift replacement cost and an earlier effective year of construction, which gives those properties a tax benefit which he is not receiving. The evidence supports, I believe that's his main argument. If the evidence supports his assertion, he stated a claim for relief because he's being assessed at a higher value than those other properties. Is there a second?
I'll second that.
All in favor, say aye. Aye.
Aye.
Aye.
The motion passes unanimously. Thank you.
Do they notify me
Chairman?
about the hearing date or something? Okay.
May I just make a comment?
There's a public comment period at the end of the proceedings. Would you call the next case, please?
Yes, thank you. Adrian Roberts Larson for the record. State Board Case number 26-114 relates to Samuel Neal Lee Revocable Living Trust, vacant land located at 72 Vallejo Verdes Street, Henderson, Nevada, Clark County, APN 179-04-803-008. Owner Neil L. Samuels filed this petition on the Clark County Board of Equalization action for tax years 2026, 2027 on the secured roll. Mr. Samuels is represented by his authorized agent, J.P. Samuels, pursuant to NRS 361.360 subsection 2. All such appeals must be presented upon the same facts and evidence as were submitted to the are submitted to the county board of equalization in the first instance, unless there is discovered new evidence pertaining to the matter which could not by due diligence have been discovered before the final adjournment of the county board of equalization. The new evidence must be submitted in writing to the state board and served upon the county assessor not less than 7 days before the hearing. The assessor submitted new evidence on July 13th, 2026, and the petitioner submitted new evidence on July 20th, 2026 for the state board's consideration. Mr. Chair.
Thank you. Who? Who will be speaking on behalf of the Samuels Neil Lee Revocable Living Trust? And who will be speaking on behalf of the Clark County Assessor?
I'm sorry, this is the court reporter. I could not hear who responded to who's appearing on behalf of the item.
Mr. Samuels, could you speak louder? And
I still cannot hear him. I'm sorry. He needs to put the microphone in front of him.
Can you hear me now?
Yes, thank you.
repeat your name, please.
My name is Jay Samuels and I'm representing Neil Samuels in this case.
Thank you. For the Clark County Assessor's Office.
I'm sorry, but they need to put the microphone in front of them. I cannot hear them. I still cannot hear her. Is the microphone on?
Cindy Robena for the Clark County Assessor's Office.
Stephanie Jones for the Clark County Assessor's Office.
Thank you. It's my understanding that we do have some new evidence presented in this case. If I'm correct, the assessor's new evidence is a screenshot of the septic system waiver request from the website of the Southern Nevada Water Authority. And Mr. Samuels, you have new evidence, which I guess there was an offer to purchase your property for $195,828 and a narrative of a conversation you had with Mario Gregg indicating you could not subdivide the property.
That is correct.
You're both offering new evidence. Mr. Samuels, do you have any objection to the evidence being offered by the assessor?
No.
The assessor's office, do you have any objection to the new evidence being offered?
Yes, because, can you hear me?
State your name for the record.
Cindy Robena. The offer was in April, after the Board of Equalization hearing. I mean, if he wants to add the new evidence, then we have a couple of new valid sales that happened after the board, the February board, so.
Stephanie Jones for the Clark County Assessor's Office. I think what Ms. Robena is referring to is if the board would like to accept the new evidence for the offer that he received, we just want to be able to speak to that offer with a few sales that happened during that time to kind of to show that maybe that offer was lower than what sales were at that time. These all happened after the state board hearing, which is what our objection is. I'm sorry, the county board hearing.
Are the sales you would like to refer to in the record?
No, they're not in the record. It's just more to speak about why the offer.
So we don't want to open the door to new evidence. Board members, there's new evidence. Mr. Samuels has no objection to the evidence being offered by the county, but the county objects to the evidence of the offer that he received for the purchase of his property. How would you like to proceed?
I mean, I'd make a motion.
Please state your name for the record.
Record,
Thank you, sir.
not to accept any new evidence this time.
Is there a second?
Kevin O'Rourke, for the record, I'll second that.
All in favor, say aye. Aye.
Aye.
Aye.
Aye.
The motion passes unanimously. Mr. Samuels, would you like to present your case?
Yeah,
Speak up,
yes.
speak into the microphone.
Yes, I do. The first thing I'd like to mention about what the county assessor's office said was that they have very many errors. The basic error, the first basic error I want to point out in their statement is that they say the property is 2,000 feet away, linear feet away from a hookup. The city of Henderson has told me that it's 3,300 feet. So in other words, it's not even close. I don't know where they got their information, but that's just the fact. The second comment I want to make is that the comps they used don't equate to where our property is. 5 of the 6 properties are 2,500 feet or less away from a sewer hookup, and most of them 500 feet or less. So what they did is they used comps that don't apply. Their whole attitude about different offers, they mentioned in the thing that we had received an offer. Yeah, it was 4 years ago, which has nothing to do with now. Our argument is about the property after AB 220 went into effect, and then the guidelines of the SNWA put a $20,000 septic tank fee. In other words, that all tainted the value of the property. We're trying to say that the property has a lesser value, and they just ignored and put in different things. They said we set the price at $499 to sell. What does that have to do? That's just a wish. It has nothing to do with what they should be doing, which is, are their comps really comparable with, in other words, does it fit our property? And we're saying it doesn't. In other words, they were being disingenuous and moving around the issue and never speaking to specifically our problems. And I just think their whole case is erroneous.
Are you done?
Yes.
Does he still have time? Then I'll ask a question.
Mhm.
Your taxable value is currently $300,000.
Yes.
What is it you're asking it be reduced to?
At a minimum, they should have taken off at least $20,000 because of the septic tank fee, which never existed since we've owned the property for 15 years. We thought it should be even lower, but our argument really is they're not taking into effect all of what SNWA regulations did to the overall area and what's happening in that area for people who are far away from a hookup to a sewer.
Thank you. Ms. Rubino, please.
Cindy Robena for the Clark County Assessor's Office. Would you like me to introduce the property? Because we kind of
No.
skipped over that. Okay.
We've read the materials.
Okay. Okay. So if you'll please refer to page 62. So in June of 2023, Assembly Bill 220 established new regulations prohibiting the installation of septic systems for new development that would be served by Colorado River water. The law also gave the Southern Nevada Water Authority general manager the authority to waive the rule if you were the owner as of April 1st, 2026. In March of 25, AB 2220 was amended to remove the ownership date requirement of April 1st, 26. Following the amendment, the Southern Nevada Water Authority implemented a septic system waiver program and began accepting waiver applications from eligible property owners, subject to the requirements for a one-time resource recovery fee of $20,000. And that's what page 62 is all about. And the reason I don't know if the new evidence got in, but thought it picked up. Okay. Okay. According to the city of Henderson Utility Department, the subject property is approximately 2,000 feet from the nearest main sewer line. So I called a second time, and the nearest hookup is 2,000 feet, and there is another one at 3,000 feet, like he was saying. But it really doesn't matter because he's over 600 feet, so he qualifies for a septic tank. So based on an estimated sewer line extension cost of $300 per linear foot, the cost to extend to the main sewer line would be approximately $600,000. So if it was 3,000 feet, it would be about 900,000. But because the subject property is located more than 600 feet, it meets the distance requirements to apply for a septic system waiver for a $20,000 waiver fee. So the comparable land sales grid is on page 26. So all of these comparable land sales sold without public sewer connections or septic systems, making them appropriate for comparison because they all have the same sewer connection issues. The comparable land sales listed vary in distance to the sewer line access. So comp 1 and comp 3 have a connection at the corner of the property. I don't know the exact distance, but if the estimated cost is $300 a linear feet to connect at 70 feet away, it will cost about $21,000 to connect to a main sewer line. Comp number 2 is 135 feet away from a connection, which will cost an estimated $40,500 to connect. Comp number 4 and comp number 5 are both more than 600 feet away. Comp number 4 is 2,400 feet away. Comp number 5 is 3,000 feet away. So they are both eligible to apply for a septic system waiver at $20,000, plus the cost of the septic system at around $20,000 or less. So a total of $40,000 or less to have a septic system installed. Comp number 5 borders the subject to the north. Comp number 6 is 475 feet away from a connection, which will cost an estimated $142,500 to connect to a main sewer line. The subject parcel exceeds 600 feet and therefore qualifies for the same waiver cost and cost structure as cost number 4 and comps number 5 of $40,000 or less to get a septic system installed. There's a vicinity map of the comparable land sales on page 33. So you can see that all the comparable land sales are located within 1 mile of the subject property and vary in size from 0.93 acres to 2.97 acres. The subject's taxable value is $150 per acre or $300,000, which is below the comparable sales range of $175,000 to $245,000 per acre. The subject property was listed on MLS at $499,990 until June 30th of 26, and a $400 offer was previously declined. The MLS listing is on page 37. Okay, a couple of issues I'd like to address. The appellant had stated that the parcel cannot be subdivided. I believe that he initially misinterpreted the SNWA waiver, but after reading his brief rebuttal on page 63, he now realizes the parcel can be subdivided into 2 lots under RS1 zoning, with each lot allowed to have its own septic system. Now the appellant states that if the parcel was split, he would have to pay 2 septic waiver fees as well as survey costs. These expenses are inherent to land ownership and development and widely recognized within the industry. The appellant does, he doesn't like my comparable sales, that they were inaccurately or improperly applied. I believe the comparable sales I used are appropriate. Using comparables at different size is standard practice and acceptable for appraisal purposes. The comparables are all within 1 mile of the subject and share similar utility conditions, meaning they will either have to connect to city sewer or pay for the waiver and install a septic system. The appellant, there's two sales that the appellant thinks that I should have used for my appraisal. One of them is a 3.71 acre parcel. It was excluded because portions of the land are unusable due to power line easements. And the 2.5 acre parcel was excluded because portions of the land are unusable due to rough topography, deep washes and such. And I think I'll wrap that up.
Hold on.
Mhm.
Mr. Samuels, do you have rebuttal?
The only rebuttal I have is I don't think the comparables they used were fair. They're incorrect. And they put in extraneous information in their comments. I don't want to say it in an unkind way, but they were all unnecessary and they never were dealing with the actual issue of the changed conditions because of AB 220 and the SNWA's actions.
Thank you. Board members, do you have any questions for the party?
I have a couple. Curtis Cadwell for the record. For the assessors, you state that those comparables he wants to use are not comparable because parts of them are unusable. So of those comparable sales that he wanted to use that you excluded, how much is unusable?
From memory, the one with the power line easements was, I would say about 2/3 of it was unusable. And the other one I didn't really investigate, but it's pretty bad.
Yeah, it'd be pretty useful to know how much. I
We
mean,
can find them.
I can try to pull it up on open web on the internet and we can look at them. We have the parcel numbers.
Can you state who you
Give me
are?
a moment. I'm sorry,
please?
Stephanie Jones with the Clark County Assessor's Office. If the board members would like, I can try to access those parcels online and we can give you a better answer.
I'm all right. I would be better prepared for that kind of question next time. It's pretty relevant. It's 10%. To me, it doesn't matter. If it's half, it's probably reasonable.
Have made an adjustment. Just
State your name for the record.
Cindy Robena for the Clark County Assessor. The percentage was, it was over 50%.
All right, thank you.
Any other questions?
Kevin Orr, just a point of clarification. You're assessing his property at 300,000 taxable
Yes, sir.
and you're asking for 280?
At this point, yes.
Thank you.
I'll just offer or ask a few questions. Ms. Urbana, what is the full cash value of the petitioner's property?
I'm sorry, I skipped over that part.
What's your name for the record?
Cindy Robena for the Clark County Assessor. On our appraisal on page 26 on the land grid, we're saying 300,000 is well supported.
You're saying it's well supported, but normally you come to a conclusion of value based on an adjustment to your comparable properties. It appears your comparable properties have not been adjusted for characteristics that affect value.
So Stephanie Jones for the Clark County Assessor's Office. When we're testing the value of our land value, we have these comparables. None of them are under what our taxable value is. So no, we did not make adjustments to the comparables to come up with what the market value is, but all of these comparables are well over what our value is. So to answer your question, no, we did not.
You did not do a comparable sales analysis. What you did was you looked at properties you thought were comparable and have said, well, we're valuing this at less than that.
Yeah, we're
But
testing.
that's different than a comparable sale analysis where you actually make adjustments. Here you've got down below on your chart, you have location, zoning, probable use, access, lot size, different things you could make adjustment for, but you haven't made any adjustments.
No, we have not. We were testing our value, not setting the value. So no, we did not make any adjustments to these.
One more thing, I didn't find out, how far they were from connections until after the case was prepared. I had to call City of Henderson and get that information for each one of those parcels. So that took some time.
I have no further question. Do any other board members have questions? Would someone like to make a motion?
Curtis Cadwell, for the record, I'll make a motion to accept the petitioner's request for a $280,000 valuation on that property.
Is there a second? All in favor, say aye.
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 Thank you.
Thank you.
Would you call the next case, please?
Would you like the next case, Chair? Or would we like to take a 10-minute break?
Oh, good. We'll take a 10-minute break at this point.
So we'll have everyone back at 10:21.
Thank you. We're back on the record. Could you please call the next case?
Yes, thank you, Chair. Adrian Roberts Larson for the record. State Board Case number 26-117 relates to multifamily residential property, West Sahara Senior Housing Limited Partnership located at 7900 West Sahara Avenue, Suite 290, Las Vegas, Nevada, Clark County APN 163-09-501-004. Managing Member George Jakakis filed this petition on the Clark County Board of Equalization Action for tax years 2024-2025 on the secured roll. Mr. Jakakis is represented by his authorized agent, Stephanie Gernauer. Mr. Chair.
Thank you. Would you please state your name for the record?
I'm sorry, I cannot hear her.
Sorry. Good morning, Mr. Chairman, members of the board. Stephanie Gronauer, 1980 Festival Plaza Drive, with the law firm of Kemfer Kroll here on behalf of the petitioner. With me is also George Jakakis, who is the petitioner and handled the appeal to the Clark County Board of Equalization.
Thank you. And on behalf of Clark County?
Good morning, Lisa Logston, County Counsel for Clark County District Attorney's Office.
Good morning. Okay, good morning, Clark County Assessor Sharon Henry.
Thank you. No new evidence. So, Ms. Gronauer, would you please proceed?
Thank you. Well, first, we appreciate the opportunity to be heard this morning. As you know, the Clark County Board of Equalization did not hear the application on its merits. It denied it simply based on jurisdictional grounds. So first, I just want to talk quickly to whether you have the authority to consider this exemption. I believe you do. There's precedent out there from 2 years ago. Actually, you heard a very similar case involving low-income housing. That case was referred to as Southwest Village Preservation, and it was case number 24-109. Importantly, in that case, you, the board, 2 years ago, just determined that number one, this board has authority to consider exemptions, has jurisdiction. Also, under your conclusions of law, you specifically said that the board has authority to review whether tax exemptions have been improperly denied or granted because exemptions are a component of the assessed value and therefore are subject to the equalization process.
Further, this board said tax exemptions are meant to accomplish a public purpose, and denying an otherwise valid exemption for low-income housing would frustrate the public purpose established by the legislature. That's why we're here today, because we think this is one of those very similar cases. The facts are slightly different, but the reality is the legislature chose and put into law that low-income housing should be tax exempt. And it's for a reason. There's obviously a huge demand and a need for low-income housing. Mr. Jakakis's project is approved and has been deed restricted for low-income housing since 2022, so for several years. So there is no question this property is intended to and can only be used for low-income housing. In fact, it's low-income senior housing, which is even in further demand. There are funds being provided by Clark County, and they have qualified for the exemption actually for 2025, 2026. The county has approved that exemption. The reason we're here and appealing this late, if you will, is because there's a procedural barrier in the process currently. We believe you can interpret state law and NAC differently, and we'd hope that you'll do that today. But currently the process with Clark County to apply for an exemption, the county asks for occupancy. And so in their application and before Mr. Jakakis can even appeal for an exemption, they ask for reports showing occupancy. We would argue that that's not appropriate. In fact, state law and the NAC specifically says in NRS or in NAC 361.089, it specifically says it can be occupied or used or will be used exclusively for low-income housing. There's no question in 2022 when the deed restriction went on this property that this property can only be used and will be used for low-income senior housing. We believe that's the way exemption applications should be looked at. Unfortunately, the procedural barrier with the county is he's not able to apply except for June 15th of every year. So this property actually became occupied in December of 2024, which was past that June 2024 deadline. The following year, he applied for the exemption both for 2024-25 and 25-26. The county approved the exemption for 25-26 because they deemed it timely, but they denied the exemption for 24-25, saying it was untimely. Again, we think this is a procedural barrier, which is similar to the facts of the case that you previously approved the exemption on, which was that Southwest Village preservation. In that case, it was a procedural mistake, so it's slightly different. That property was exempt and the exemption had fallen off, and you, the board, corrected that error, if you will. Here, it's a procedural barrier in our mind where he's handcuffed. He can't apply till June. The property's occupied and certainly will only be used for low-income housing, but isn't able to apply for that exemption till the following year. His relief is to appeal. He appealed, and then he's told he's untimely in that appeal. So that procedural barrier is a handcuff for him, and it's not a proper one. It's not what the legislature intended. It's not what the actual case law says that you all have seen before, or the statutory and NAC language. I don't think requires occupancy. I think it certainly contemplates that it has to be used only for low-income housing, and that deed restriction requires that it be only used for low-income housing. So we're here seeking relief. It's the right thing since that's what the legislature intended. We believe it's within your power and your jurisdiction to grant that exemption. We appealed it as soon as we practically could. It made it impossible to have appealed it the year before because he wasn't able to apply for that exemption. So here we are. We would ask for you grant that exemption, or alternatively you remand it to the county board and ask them to hear it on the merits.
Thank you. Does she have time left? Is the application in the record?
Yes.
Can you point me to that?
Sorry, I'm looking for it. I know if it's not in the record, it's certainly referenced on page 24, where the applicant applied for the exemption for 2024, 2025, and 25, 26 on May 6th, 2025. I'll keep looking. I did think it
Well,
was part of it.
It's my understanding that the application also requires a status report from a housing authority.
Correct.
Do you know when that status report from the housing authority was obtained?
So we were talking about that. It certainly could be obtained earlier. It just procedurally has not been allowed until occupancy. Certainly, we could obtain a report that would say it will be occupied for 171 units, senior housing, and what those rates will be, but it was not provided until the application on May 2025.
Ms. Logston?
Good morning, Lisa Logston. Kind of want to break this into kind of three sections. So our first objection is that the application was untimely. The petitioner is seeking a tax exemption for the 24-25 tax year. NRS 361-155 and NAC 361-089 require that the application be received by June 15th of 2024. The assessor did not receive the application until May 6, 2025. Under NAC 361-155, subsection 6, if a claim for a tax exemption on real property in any required affidavit or other documentation in support of the claim is not filed by the time required in subsection 1, which is the June 15th date, or if any claim is denied by the assessor, the person claiming the exemption may on or before January 15th of the fiscal year for which the claim of the exemption is made and any required documentation file with the County Board of Equalization. Here, the petitioner's claim should have been filed with the County Board of Equalization on May 15th of 2025. But instead, the claim was not filed until January of 2026.
You said May 15th?
I'm sorry, January 15th.
January 15th.
Yeah, January.
Right, because the deadline for the application was May.
Was
but-
June 15th.
was June 15th, but really in this case, it's that January 15th because 361-155 subsection C essentially allows somebody, even if they didn't file their application timely, to file an appeal to the county board by January 15th.
That is correct,
And so that's the deadline. That's the hard and fast deadline we're dealing with.
especially for exemptions,
January 15th.
2025.
Yeah.
So therefore, the petitioner's failure to timely file by January 15th, 2025 deprived the County Board of Equalization of jurisdiction and therefore depriving this board of jurisdiction. The petitioner has relied on a prior State Board of Equalization decision regarding a low-income housing that was referenced previously, but that case is not similar to this one. In that case, which I believe it was the Nevada Department of Taxation versus Southwest Village Preservation. In that case, there was a change in ownership and the tax exemption improperly fell off and the assessor's office was looking for a correction in that. That is not the case here. Here, it was not timely applied for. And so that is why we believe this appeal should be denied for jurisdiction and being untimely. The second set is that this property does not qualify in the 2024-25 fiscal year due to the requirements for low-income housing. The statute requires it to be either occupied or used by qualified residents or will be exclusive use for low-income residents as of June 15th of that year. So the regulations that have been adopted by the Tax Commission have put that residency requirement in there. And then specifically in NAC 361-089, subsection 3, subsection C, it states for an initial application, a copy of the first quarter of annual status report for the project issued by the appropriate housing authority, showing the number of units, the size of the units, the names of the tenants occupying those units. So therefore, the legislature and the state taxation department adopting these regulations, they're interpreting this law to be that it needs to be occupied by June 15th of the fiscal year. And this is a tax application that is applied for each year, unlike general tax exemptions that are usually applied for once. Tax exemptions in the state of Nevada are required to be strictly construed. The interpretation requested by the petitioner is not supported by the statutes regarding low income. And as I've stated before, the June 15th deadline is very important when it comes to tax exemptions. So we would request that the appeal be denied. Thank you.
Thank you. Time for rebuttal.
Thank you. So the taxable value of this property is
Again, state your name
$26
for the
million.
record.
Sorry, Stephanie Gronauer for the petitioner. The taxable value for this property is $26 million, which is a significant tax burden on an entity that is supposed to be tax exempt. And I think we're here today seeking your help to get past a procedural barrier that respectfully we disagree with. I know the county interprets that in order to apply, you have to have physical occupancy, but I would disagree that the NAC contemplates that it will be used exclusively for low-income housing. That language is in the NAC. It says used or will be used exclusively for low-income housing. As I mentioned, certainly a report would be easy to produce. The property is deed restricted. We could outline the 171 units and break all of that down and provide that in a report. But currently there's a procedural barrier with Clark County where applicants like Mr. Jakakis and others are unable to apply for years that they should be tax exempt. The homes were occupied, if occupancy is the standard, by December of 2024. So he had occupants in their homes that year. He just wasn't able to apply until the following year. And so he did seek relief. He did appeal in that following year. But unfortunately, there's no opportunity to apply proactively or, beforehand when we think that that is in fact what should be, how it should be interpreted and how it should be handled. We disagree with their interpretation. We'd ask for your help. We think that you have set precedent in that Southwest conservation or preservation case where you looked at very similar facts. That was a procedural error where you corrected it. We think this is a procedural barrier where he is exempt. There's no question. In fact, they've granted it for 25, 26. So he's met all the thresholds. There's no question whether this project is a tax exempt project. It's just that procedural barrier as to when he could apply for it that has created a significant burden on him, a burden so much so that he's going to pay taxes on a property, significant taxes on a property that the legislature didn't contemplate he pay.
Thank you. This is an area in which I do have some experience. I've dealt with this issue before. And it does not appear that there's any dispute that the property at issue qualifies for the exemption provided in 361082 for tax year 2025-26. In fact, the assessor has acknowledged that it meets the statutory requirements for exemption by granting it tax exemption status for 2025-26 tax year. There's a question about whether or not it should qualify for the exemption in the preceding tax year. The statute provides 3 categories of properties that can qualify for the exemption. The third category of property is for units which will be used exclusively as low-income units. This category clearly contemplates the situation where the taxpayer's exclusive use of the property as low-income units will occur at some time in the future. This category makes no mention of there being qualified residents. Thus, a reasonable construction of third category of exempt property is that the units are exempt so long as the units are dedicated to be used exclusively as low-income housing units. In other words, the property qualifies as being exempt in all other respects under Nevada Revised Statute 361082, whether it is presently occupied or used is not determinative of whether the exemption applies. What is determinative is whether the property is dedicated to being used exclusively as low-income units in the future. Thus, the third exempt category of property found in section 361.089 is entirely consistent with the definition of used exclusively as found in the low-income housing exemption statute 361082. So I think so I think for the tax year at issue 2024-25, it should be treated as exempt property. The problem is, as Ms. Logston pointed out, NRS 361.155 subsection 6, even though you didn't file an application, would require that you file your petition with the county board by January 15 of 2025. The petition you filed is a year late. Does this board have the ability to recognize it as a timely appeal? You know, I think that as you pointed out, there is a regulation that requires certain materials, and that one could be confused by those materials and think that well, we can't file it until we have that information available, and therefore we filed it as soon as the information became available. One could argue that there's been some kind of equitable tolling of the period of time, and that justifies this late filing. You rely on the Southwest Village Preservation case, a very unusual case, but it was a case in which all the parties agreed to the result. You've got the state board essentially applying perhaps an equitable tolling type of argument, but the decision specifically says that the Department of Tax did not oppose reinstating the exemption. Washoe County did not oppose reinstating the exemption. There was everybody agreed to that result. I don't think we're in that situation today. I don't think we're in a position where Clark County is going to agree to the result. So it's a question of legally, can we apply it? You know, I think in this situation, we have a fixed deadline of January 15, 2025, established by the legislature. That was not met. I think that from an equitable perspective, you deserve it to be exempt. The legislature's intent in passing a tax exemption is to aid charitable institutions by relieving them of the tax burden, and thus assist in carrying on a purpose deemed of benefit to the public good. Consequently, denying an otherwise valid exemption would frustrate the public purpose established by the legislature. So I think it should be exempt. But the question is, can we get there? Do other board members have thoughts? I've gone on and on.
Well, I have thoughts, and it's very much a legal issue. To me, it seems extremely confusing, this Curtis Cadwell, for the record. How are you supposed to know what to do when what you have to file says you have to have occupants? I mean, that's, I don't know. Seems like Clark County has a problem, but Yeah. The legal interpretation of whether we can take that on. Pretty straightforward to me, how I would vote on it, but I don't know whether legally we're allowed.
Do any other board members have comment?
Yeah, Kevin Orrock for the record. When was the deed restriction put on?
Stephanie Gronauer for the record. It was recorded in 2022.
So there was an exemption in that the 22, 23 year, you got the exemption?
There was not. There should arguably, perhaps that should be the direction maybe from this board and moving forward, is that we should apply as soon as the property is deed restricted. They applied the year of occupancy. It just unfortunately was after that June 15th deadline, but I wouldn't disagree with that actually.
You quoted where you said that the exemption is in place with the deed, and the assessor's office is saying it's occupancy, or is it just a timing issue that you failed to make the application? I'm a little confused between occupancy, the filing of the deed restriction, and then the timing of the application of the exemption.
If I may reply through you, Mr. Chair, sorry. Stephanie Gronauer. The applicant submitted for the application after occupancy because their understanding from Clark County was that was the requirement, which was in May of 2025. The statutory deadline to file is June 15th, and they did not, they were occupied 6 months after that. So unfortunately, that makes them unable to even seek an exemption until the following year. They did seek the exemption the following year for both years. However, they were denied for it being untimely. So we're in this, it's a procedural barrier from our perspective because there's no opportunity for us to file. Perhaps this board could give direction that applicants like this should just file before occupancy because it is deed restricted and can only be exclusively used for senior low-income housing. It's been deed restricted since 2022. We're trying to comply with the procedural barriers that are in place with Clark County. And unfortunately, we're in this predicament where we weren't even able to apply until May and then the appeal period for the following year. So it's one of both occupancy and the timing to file for exemption.
I do know for a fact that property owners have filed timely for situations where the project's under construction,
okay,
where they don't have occupancy. Did you contact the assessor's office and ask them if you could apply? Did they provide you any advice regarding applying?
George Jakakis, managing member of West Sahara Senior Housing Limited Partnership. No, I did not. I try to follow the NAC and their procedures on that. So I'm kind of bound to that. We have started now currently, since this appeal, all of our new properties in pre-development. The moment a deed restriction is put on it, we have started filing very early. We know it's going to be denied because you've got these barriers that the NSC has compared to what NRS. And the reason we're so adamant about receiving tax exemption for that third and fourth quarter is because it takes a lot to make affordable housing work these days. It takes state coming together, it takes the county coming together, and receiving home funds is a requirement.
Thank you.
But just want to say, we just want to pay back some of our money that we borrowed from Clark County. We borrowed over $6 million from them, and that's what this exemption refund is, would go to. Would go right back to Clark County.
Thank you. Do board members have any further questions?
Corey Burke for the record. I guess
This question is for Clark County. Had the appellant applied, would his application have been denied based on occupancy?
Lisa Logston for Clark County for the District Attorney's Office. I want to clarify too that this is not Clark County's process. This is a state form that is handed down through the NAC regulations. So the state application comes through to the county, but the state, pursuant to the regulation, creates the application. So this is not a county process. I just want to clarify but for the record. But to answer your question, Member Burke, it would not have granted the because it was not occupied or couldn't provide the information required by the NAC by June 15th of that fiscal year. So as the petitioner has testified, they were occupied by December of 2024. The county is not permitted, there's no statutory authority for the county to authorize prorated tax exemptions except for in two situations by statute, which is for when governments purchase property and when churches are purchase property, they are entitled to a partial year tax exemption.
Are there any other questions? Would someone like to make a motion?
Dana Cook, for the record from the Attorney General's office. Just for the board, some legal advice, some of the jurisdictional challenges have come up. And there is a case from the Nevada Supreme Court that does say the court has never applied the doctrine of equitable tolling to statutory periods that are mandatory and jurisdictional. Just for the record, the case is Sino versus Employers Insurance Company of Nevada, 121, Nevada 146. So I would just advise the board that to take that into account, that equitable tolling has never been applied, for these to toll statutory periods that are mandatory and jurisdictional.
That puts a damper on things.
Kevin Orrock, sounds, I'm not a lawyer, so I'm the business guy, but I would make a motion that that the exemption, that they get the exemption in the 2025, 24, 25 calendar year.
Is
Fiscal
there
year.
a second?
Curtis Cadwell, I'll second it.
Is any discussion on the motion? All in favor, say aye.
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 Nay.
Thank you.
Thank you very much. Appreciate it.
Mr. Chair, are you ready for the next case?
Yes, please call the next case.
Adrian Roberts Larson for the record. State Board Case Number 26-124 relates to residential property, Fort Apache Townhomes LLC, located at 9930 West Flamingo Road, Suite 110, Las Vegas, Nevada. Clark County APN 176-19-714-001. Trustee Vincent Shetler filed this petition on the Clark County Board of Equalization Action for tax years 2026, 2027 on secured roll. Mr. Shetler is represented by his authorized agents, James Wadhams and Jerry Rusty Graff. Mr. Chair.
Thank you. Would you please, Mr. Wadhams, would you state your name for the record, please?
Yes, Mr. Chairman, thank you. My name is Jim Wadhams with the law firm of Wadhams Advisors here today on behalf of Fort Apache Townhomes. And on my right is John Sullivan from Fort Apache Townhomes LLC.
And on behalf of Clark County, who will be presenting the case?
This is Melody Garfield for the Clark County Assessor's Office.
Stephanie Jones for the Clark County Assessor's Office.
Lisa Logston with the District Attorney's Office.
Mr. Wadums, would you like to proceed?
Thank you, Mr. Chair and members of the committee. Again, my name is Jim Wadums for the record, here on behalf of Fort Apache Townhomes. This is a fascinating case, and it really is unique because it is essentially a prisoner of time. In the years leading up to 2024, there was no provision in the Clark County Code that would allow projects like my clients, Fort Apache Townhomes, to be a single owner, multifamily townhome rental project. That was corrected in 2024. However, my client came up with this idea in 2022 and sought to take that project to Clark County Building Department to be approved. They indicated that it would not fit in the code and jerry-rigged another way to accomplish this, and that would be to file as a PUD, planned unit development, and then they could operate it as a rental unit. As I say, 2 years later, the code was changed to specifically authorize townhomes to be the elements of a single owner, single parcel multifamily project. So what brings us, and as far as I can tell, and reading the record, reading the briefs of both parties, there's no dispute that this has been operated since inception as a single owner rental project. There is no dispute that if it had filed in 2024 under the new code, it would be treated as income producing property and evaluated using a capitalized income approach. There is no question that no sales have been made. And in fact, the client has never taken the steps that would be necessary, filing CC&Rs, forming an HOA, obtaining permits, disclosures with Nevada Real Estate Division. There is no legal way that individual elements of this current project could be sold individually. So what brings us here? We have a dispute over valuation. To make it simple, roughly 28 million the county assessor has come up with. An expert on behalf of the client has done the capitalized income approach and come up with 24 million. That's 115% significance. That's approximately $3.5 million difference in valuation. The county insists that the assessor's office insists that it's done by comparable sales of individual standalone units of townhomes. And those are then aggregated for the full 79 units that are part of this project. Taxpayer, not surprisingly, suggests it's a single rental project and should be evaluated using a cash flow, a capitalized income approach, in the same manner that a willing buyer would make an offer to find out what their return on their investment should they buy the entire project. So that essentially is the issue we have. And it's locked in time because as far as we can tell, this is the only project that was done under the old code that doesn't specifically permit townhome. And so we are faced with a situation from 24 forward where a project otherwise identical to Fort Apache Townhomes will be evaluated as an income producing property. Fort Apache is locked in this time warp and will be evaluated according to the county by an aggregation of calculations of individual sales of property, which cannot legally occur. That cannot legally occur. They cannot be sold individually at this point in time. The client has never perfected the right to be able to do that. And as I mentioned rather briefly, they'd have to file CC&Rs, obtain approvals of Nevada Real Estate Division, the whole host, and redeed the property. It sits under a single deed at this point. So essentially, in reading the briefs, the argument between the two parties really is of that difference in valuation, but it essentially pivots on the application of the law. Do you use comparable sales for a rental project, or do you use cash flow analysis? Canyon Villas Supreme Court case decided that for income producing property, the capitalized income approach is more appropriate. Comparable sales, we have a problem with that because these units can't be sold individually, A, and B, if it were sold, it would be sold to a buyer who would buy the entire project because that's how it's deeded and financed. So comparable sales, we think, are clearly inappropriate, and the principle of valuation is being misapplied. Under 361-227, we believe that the statute requires that the land must be evaluated in accordance and consistently with the use to which it's put. So if it's put to use as a rental property, it becomes a rental property. It's put to use for sale, it becomes a sale property. As I read the assessor's response brief, they clearly take a position contrary and state specifically, and I quote, valuation must be based on physical characteristics, not occupancy or ownership. And it is our belief that that is directly contrary to what NRS 361-227 says as the basis of valuation. We think there's other elements that could be applied in satisfying our burden of proof that this is the wrong principle, but they all seem to be redundant and pivot around that notion of how do you evaluate, how do you assess property? And we believe that the statute and the Constitution, for that matter, require that it be done consistently with the use to which that property is put. As this board is well aware, there are absolutely identical properties. And the example that pops into mind, 7-Elevens, they may have distinctly different taxable values, depending on that capitalized income approach. One located in a prime area could have a much higher value than one located in a remote area. Physical characteristics that are otherwise identical, with the exception of the site adaptation that the architect might otherwise do. So this notion that physical characteristics trumps use, we think, is inconsistent with the statute and simply should not be allowed. The problem, again, will continue to develop with properties similar to Fort Apache that are done now in the county after 2024. And simultaneously, if one had been done in the city of Las Vegas, which allowed townhouse projects, and city of North Las Vegas, you would have properties identical in terms of their use and function that would be appraised, assessed differently. And we think that would violate the uniform and equal provision of Article 10, Section 1 of the Constitution. What are we asking? What are we asking this board to do? Simply to equalize the value. Frankly, I think a determination that it is use, not just physical characteristics, it's the use of those physical characteristics that determines whether a project is income producing, residential, for sale, whatever it may be, whatever use it's put to. I think that is we believe that this board should affirm that that is the principle that determines the mode, the modality, the technique of evaluation to reach full cash value. And in conclusion, 361-025 defines full cash value as what a willing buyer would pay a willing seller. And when the willing seller can only sell the entire project, the willing buyer is likely to do a capitalized income approach to see what a reasonable offer for that property might be. In the record, an entity called Northmark, as a major broker in this section of the marketplace, put those values in the record and produced a capitalized income approach valuation of $24 million. So we would ask this board either set that as the value or remand to the county with direction to use and treat this as what it is, an income producing property owned and controlled by a single owner. Happy to answer any questions. Appreciate the time.
Thank you. Would you like to proceed? Go ahead.
Ready. Melody Garfield for the Clark County Assessor's Office. In Nevada, as you know, we start with the cost approach, and that is what our taxable value is. We add the market value of the land to the replacement cost new, based on Marshall and Swift, and then we subtract the 1.5% annual depreciation. Because these are structurally built as attached residential townhomes, Marshall and Swift tells us here are the costs for attached townhomes. And so those are the costs that we use. Marshall and Swift says townhouses are single family attached residences that do not have other units above or below, do not have more than 2 walls that are common with adjacent units, and always have individual exterior entries. This is an exact physical match for the subject property. So these are the cost tables that we look to when we value the property at cost. That's where we start. All good.
Ms.
Okay.
Garfield,
Crucially-
I don't think anybody is questioning your
Okay.
application of Marshall Swift to determine the initial taxable value of the property.
Excellent. I'll
Are you-
continue.
So, but my question is, are you using the cost approach to determine the full cash value of the property?
We test the cost approach. Once we've determined the cost approach,
you're
we
not-
then test it
You're not using
with
the
full
cost
cash
approach,
value.
because the argument on the petitioner's made is concerns full cash value.
Yes,
So could you focus on full cash value?
absolutely. Crucially, Nevada law requires us to appraise the property, not the business operation or owner. Whether a townhome is owner occupied or rented out by an investor, identical physical structures must be valued uniformly. That's where we talk about the Constitution and the uniformity clause. So we don't look and see, well, this is a townhome and it's rented or it's occupied by the owner. We have many investors throughout the county that own portfolios of single-family residences, townhomes, and they consider that one economic unit. But how are we going to appraise their property differently than the property next door that's occupied by the person who owns it? We don't value it that way on a portfolio basis. We looked at the sales comparison approach for these individual attached townhome parcels. Individually parceled townhomes typically trade, and the sales comparison approach is the best method of valuing those type of properties. And so in our briefs and in the case, starting on page 103, we have our sales comparison analysis. And these are full cash values. This is what we are saying the range of values is. We're going to the median. We have these valued starting at 300,000 for the smallest parcel, up to 374,000 for the largest parcel. Altogether, that totals $27,632,462. Our sales comparison approach indicates that the smallest model, the sales adjusted sales range from 319 to 370. Well, our cost isn't higher than that. We are not exceeding full cash value for that single family attached townhome residence. And we're about 40,000 below that market value. Because these properties, well, and that's pretty much for all of the models. We're about $40,000 below what full cash value would be. We have a range of sales. We chose the median, and we're about $40,000 below that market value when you evaluate them this way. Next, we chose to look at the income approach. Now, there's lots of ways to look at the way income and rent, are associated. And the gross rental multiplier is the way you use the income approach for individually parceled, single family attached townhomes. That's what this project is. So on page 119, we do have a gross rent multiplier analysis, and we determined that the gross rent multipliers, we found similar townhomes that are rented. And we looked at their sale prices that were recent to the times they were rented and their rental income. And we came up with a multiplier for those properties. This is another method of income valuation. It's often applied to individually parceled, single family, attached residences, and detached residences. So we came up with a GRM. It ranged between 14 and 18, and we chose 16. And on the following page, I believe it's 120, we apply that multiplier. This is an income approach. It's simple, but you don't have to worry about what all these other factors are in the market. And it works for these types of properties. This is a very common way to do it. And we came up with none of those values using these multipliers were less than $400,000. So we're at between 300 and 375, an average of 350. So again, we applied these two approaches to value, which are typical for these types of properties. We do not exceed market value. So now the appellant wants to argue that the 79 parcels should be valued as one single bulk apartment complex. Again, these are not apartments. So just, even if we perform that calculation under an extraordinary assumption, mind you, that's on page 124. We used market evidence for vacancy. We used a 5% cap rate. The resulting value using this approach is $415,000 per unit. We're on at an average of $350,000 per unit. Again, we do not exceed market value. So finally, please let's look at the case law because he brings up Canyon Villas. We'd like to also bring up Montage. I'm sure you've seen it in our briefs. So Montage and the petitioner in this case rely on Canyon Villas to argue that the income capitalization approach is appropriate due to the property's use as an income producing property and due to the investor owner's intent to use the property per se. Now, like I said, we have lots of investors in town. They own hundreds of properties, maybe. To them, their hundreds of properties are considered one economic unit. We do not value them that way because it is unfair, it is inequitable to all the other similar homes and townhomes in their neighborhoods to value them that way. So this exact legal issue was settled by the Nevada Supreme Court in State Board of Equalization versus Montage. The case starts on page 133. I'd like to point you to page 147. Just like in Canyon Villas, Montage and the petitioner are relying on that case. Quote, I think I have it highlighted on that page. And you're all familiar with it, I'm sure. I'd just like to read it into the record since I have 8 minutes left. The property at issue in Canyon Villas, an apartment complex, is clearly distinguishable from individual residential condominium units. Thus, Montage's reliance, and I would argue the petitioners, the reliance on Canyon Villas is misplaced. Moreover, county assessors must use the valuation approach. It doesn't say may. It says must use the valuation approach that most accurately measures the full cash value of the property without consideration of the owner's identity or intent. The assessor in this case utilized the sales comparison approach, which is the approach generally used by appraisers in valuing individual condominium units, and Montage's status as an investor does not warrant valuing its units differently than those of other owners. To hold otherwise would result in a determination of value as an investment or their value to the current owner, not the full cash value, which is the price that each unit would receive on the open market. Furthermore, the court confirmed on page 142 that there is no statutory authority to discount or value fully developed individual parcels collectively as a single unit, which is what they're asking us to do here. The legal impossibility that they are talking about, they cannot sell these units. That is a voluntary choice. That's their operational choice to do that. They can sell these units. There may be a few hoops to jump through, but they can sell these units. And we are well enough below market value that there is something built into that. In addition, comparing it to apartment homes, I understand their broker's opinion of value. That is the value to this investor. This investor is saying, I want to sell all these homes in bulk value. There is nothing legally requiring them to do that. They might have financing issues. There may be something that they're saying is preventing it, but it isn't a deed restriction. It isn't a legal restriction. It is their choice to hold these properties like this. Lots of people, when they sell their properties, they got to pay off the loan, before the new owner can take over. There are expenses to anyone that is selling any property. But I'm saying that this opinion of value that they have provided is an opinion of the value to this investor. It is not what we are supposed to do as the assessor. The assessor cannot grant lower tax valuations or bulk discounts based on private encumbrances, financing choices, or self-imposed administrative delays. In conclusion, the property is 79 individual fee simple townhome property. That's how we appraise them. The statutory cost approach was correctly applied, as I think you mentioned, everybody here agrees. The market sale, the sales comparison approach, the single family gross rent multipliers, which is also an income valuation approach appropriate to these types of properties. And even under an extraordinary assumption, a cap summary, a capitalization approach that we completed, proved that the taxable value is well below full cash value. Montage prohibits giving investor owners a special bulk discount valuation over home owning neighbors. We see this as a violation of the Constitution if we were to do that. Equalizing the value of these parcels to that of a multifamily apartment entity, it violates the statutory guidelines. It violates Marshall and Swift standards for valuation. It violates Nevada case law, as we've discussed, and the uniformity clause of the Nevada Constitution.
Thank you. Any rebuttal?
Yes, thank you, Mr. Chair. I think it's very helpful to think again about the 2024 code, which is what we're under right now. Single parcel, single owner, horizontal apartment complex. This suggestion that conjures up in at least my old mind that an apartment is a building where everything is within four corners is no longer applicable. So we have town projects, we have duplex projects, we have all sorts of configurations that renters want to rent in. And that is precisely the market that Fort Apache was trying to address, which ultimately Clark County in 2024 modified their code to accommodate effectively the tax status of an apartment house for a single parcel townhome complex. It has equated the two. And to suggest that it is appropriate to do that assessed valuation, deconstructing that and comparing it to standalone values is the same thing that you would do with an apartment complex. Let's evaluate it as condominiums. And some of us were in this valley when there was a huge shift from condominiums to apartments and back and forth. That's clearly not what the code suggests. Mr. Sullivan has tapped on my shoulder, and if the chair wouldn't mind, I'd like to give him the opportunity to say a few words, please.
John Sullivan, the petitioner, Fort Apache Townhomes. So again, I think we're really sitting in a little unique position. First, I'll address Montage quickly. We would agree with the ruling in Montage. Montage was a for sale product. They had taken all of the steps, HOA requirements, 116 requirements, everything to do to sale, went into a hard economic time and started to rent some units out of necessity and said we should be able to treat these units as rental units. Our development is different. When we got this approved in 2022, within the same jurisdiction that's under this assessor, had we done it in North Las Vegas, they allow for townhome clusters to be on a single lot. Was this done in Las Vegas at that same time? City of Las Vegas, again, under the assessor's jurisdiction, they allow for single lot townhome projects. It's within the brief that we provided to the county. That's in the record. It's the first letter of that December 23. So in Clark County, they knew they had a problem. We submitted the project as a single parcel townhome project. They said we can't accommodate that. We were on a multifamily parcel, an R3 parcel at that time, now called RM18. They said the only way we can accommodate this product is to downzone, just basically they figured out a way to jury rig a scenario that allowed us to build what we intended to build in a way that had to be unique for the county at that time. They knew they had a problem. As part of the development code restruck, they corrected that. And were we 2 years later on that project? So anybody building right next door to us or anything of that nature can build a single parcel townhome project that looks 100% and operates 100% just like us. And the county has said on record in these cases, if that were the case, if we were on a single parcel, we would be treated under the income approach and they would treat it as a single economic unit. So the one difference is we were required after submitting as a single parcel to work through a scenario with the county as they were trying to be accommodating. It wasn't an adversarial, but we can't do what you want because the code won't allow it. They didn't have a townhome category that would allow for that. So we went through and built that. So now we're in a scenario under the same assessor. And by the way, the county now refers to that as a multifamily
You have 1
product
minute remaining.
in townhomes. Thank you. So we're under a scenario where anyone who has or will build in Las Vegas and single parcels it, anyone who will build under the code now, doing the exact same project in the same competitive marketplace as us, because of this, we're going to be property tax assessed, or the county is trying property tax assess us different. And that's the uniqueness of this case, as opposed to someone who owns 5 homes that all could be sold in a moment. We've never deeded the properties individually. So right now, a typical for sale would say you've got a fee simple in this unit and a 1/79th interest in the common areas. There's a deed over the whole 7.5 acres, one single deed that still runs the property. We haven't taken any of the steps through the ombudsman or NRED to take any of the steps that would be required. And so the county would be made aware if that ever happened under the deed. These are done year by year. If I'm just going to finish a sentence, these are being done by year. If we ever take a step to change the deeds, or the county is made aware. If we ever go to NRED or ombudsman, the state's made aware. And on those years could be reevaluated as a for sale product. But we're really stuck in this little being treated as something different than what we are. Thank you.
Thank you. No, you may not. You were given your opportunity to respond to their opening. They get the reply. That's it. Questions may come and then you can respond to questions. This may be repetitive, but it's my understanding. For purposes of calculation of the taxable value, we use a valuation date of January 1st or January 15th of, for this tax year, it would have been 2026. So as of that date, could these units be legally sold separately?
No. John Sullivan, petitioner. No, they could not. There are legal steps that would have to be taken to make them available to be sold.
Have individual units been marketed for sale?
John Sullivan, no, sir, never.
Have any individual units been sold?
No, sir. John Sullivan, sorry.
The valuation you had done by this company, they mentioned some sales of other multifamily properties.
Correct.
Are you familiar with those sales?
Not familiar with the exact location and dates and circumstances, but do have the opinion of value here.
I'm trying to think, what page is that on?
I don't have the whole record in front of me, so I could use help with that, but it's attached to the starts on page 48, I'm being told. But it's part of our appeal to the county board. It's attached as exhibit to that.
Am I to understand that your property is unique, that there are no other rental communities? No, it's not unique. There are other rental communities that are separately parceled.
So what I would say is there are single family homes out there, the American Home for Rent product and things like that are single. I don't know about any townhome product. Obviously, in the last 10 years in the Valley, there's been an increased demand for affordable housing and rental housing as prices have gone through the roof. And so this rental concept is relatively new. And so that's why the Vegas and North Las Vegas had already addressed it and why the county has addressed it in its most recent development code. I expect a lot more, but I don't know. I can't say there are none, but or ones that sit on a single parcel or multiple parcels. I don't know the answer to those.
Well, if, um, as of the valuation date, you could not sell this as an individual parcel, how would you sell it? At that point in time, how could it be sold?
The only way it could be sold on that date would be as one economic unit. There's one deed over the entire property right now, and there's none of the requirements to sell portions of that off that have been met. And that's the way Northmark valued it, as a single economic unit.
Now, in the materials, the county has quoted repeatedly the notion, the NRS 361-227 subsection 2, that indicates the unit of appraisal is a single parcel. But that is the lead-in to the exceptions.
Exactly.
There are two exceptions here that are, both of which may apply. The first one, subsection 2A, is if the location of the improvements causes two or more parcels to function as a single parcel. And in this case, even though you've got these separately parceled to solve a bureaucratic problem that existed a few years ago, even though they're separately parceled, they are configured in a way, the improvements are configured in a way that causes them to function as a single parcel. You know, they've got shared walls, you know, the improvement, the construction, it's a big building. You can't sell it individually. Well, how can you sell it? So this 2A seems to be an exception that may apply in your case. Similarly, 2C, it says the single parcel is not the unit of value if, in the professional judgment of the person determining the taxable value, parcel is one of a group of parcels which should be valued as a collective unit. In this case, your Northmark, in their opinion, in their professional judgment, concluded that the way this would be marketed and sold is as a multifamily rental development, not as single family units. They made the decision that the parcels are a group of parcels which should be valued as a collective unit. So I think this so I don't think there's any legal limitation on this board's valuation of it as a single unit. And the you know, and as the county's pointed out, in determining the full cash value, the assessor must use the valuation approach that most accurately measures the full cash value of the property. Well, full cash value is the price which property would bring in a competitive and open market under all conditions requisite to a fair sale. This requires a consideration of, well, how would this property, how would a seller and buyer, how would they sell the property as of the valuation date that we're dealing with for this tax year? And I think it is as a collective unit. And we know from the, as you pointed out, from the Canyon Villas case, that if you're valuing it as a collective unit, as an income producing property, the income approach is the way to go. And, I think they're, yeah. So those are my preliminary thoughts. Other board members, do you have any questions or comments?
Yeah, Kevin Orrock for the record. I appreciate the county's position. I understand it. But quite frankly, I think the petitioner to get to your value, because it is a rental community, and for them to get to your value, they'd either have to significantly increase their rents, or they'd have to get a buyer to come in at a very, very aggressive cap rate, which at that location, I don't think that could happen. But so I think it's got to be done on an income approach. And I think I agree with to make a motion. If no one else has.
Well, let's see. Are there any other comments from board members?
I've got a couple. Just, if you wanted to sell them separately, what's the cost of getting there?
There's a time, pardon? Oh, John Sullivan, for the petitioner. There's both a time element and a cost element to what would need to be done. It's not dramatic dollars to go through the process of getting all the NRED approvals and ombudsman and get the HOA formed. It's not an outrageous amount to get CCNRs prepared and put those, but each of those are just months of time and effort. And it's not, and obviously we could prepare deeds for the 79 units in the common areas and all of those things. So I don't know if it's 20 grand or 25 grand. It's not, the dollar amount isn't an insurmountable amount, but it's a process step that would acknowledge that we're changing the use, as opposed to we've been very clear that we haven't even deeded the properties as 79 individual units because it's never been the action or intent.
And another question, the code modification, I mean, I'm trying to understand why you'd want, other than to save money up front, I would assume, because you don't have to subdivide and everything else, or what's the rationale for building big units of single family housing on a single block of land? That's sort of a foreign concept to me, but I mean, clearly people are doing it.
Well, when you have a for rent product, whether it's on multiple parcels or single parcel, it doesn't change the way the operation is. So going through the steps of putting it on multiple parcels wasn't something that was contemplated here. We submitted a single parcel development, had the county tell us they couldn't accommodate it under the existing, that we would have to modify in this way to continue to build that product. And downzone the property essentially into one of a different category. So everything's a choice. There are some costs that come with having multiple parcels, because you have to make it so every unit could stand on its own if you went down that other path. So there are some of those kind of costs, but the intent was always to go in this single. And like I said, it was just a really odd moment in time, a couple of years ahead of the final approval of a revision in the county that made it different than the other jurisdictions.
Understood. And for the county, why, what are you guys doing right now with anything similar that's built under the new code? Are you assessing it under an income approach, or?
I don't know of any properties like that yet. Under Title 30.
Can you please state your name?
I'm sorry, Melody Garfield for the assessor. Under Title 30 now, it's still considered a single family attached dwelling. It does say that townhomes developed on a single lot are permissible, but under the code, the way it is now, it's still considered single family attached. Now, our cost approach for the improvements is going to be the same, right? Because it is a townhome and we're going to value it as a townhome via Marshall and Swift. The difference in the two values, if it was all the parcels, all of the improvements on a single parcel, would be the land value. And right now we have it on as residential land value, and it ends up being about $1 million an acre. And actually our multifamily land value is much higher than that per acre. So, I mean, our cost approach would, maybe be higher. Again, we would test it differently, because once we come up with our cost approach, we have to then test it with the income approach. And we would try to find sales that we could use that are more similar to apartments, but, we would try to find those sales. These have been compared to apartments, which I don't think is completely accurate, but we just don't think they should be appraised like that at all. So,
And what about North Las Vegas, where they have allowed this for quite a while? How do they?
I have not looked at those. I mean, I haven't seen any sales come through for North Las Vegas that are multi-townhomes on a single parcel. I guess if I saw some sales, I could answer that, but our philosophy has always been to do this according to statute and uniformity. So we just looked at,
I think the testimony was that in North Las Vegas, you could build these on one lot. You did not have to subdivide. So the comparables that he's talking about are not individually parcel townhomes, but townhomes built on one parcel in North Las Vegas.
so.
Yeah, and my question is, how do they assess those? Do they
So
do the
again-
income approach or not?
Again, we're just looking at the cost approach and we just put them on as the cost approach. If we were testing, which I guess they would have to appeal those values and then we would compare it, but
Stephanie Jones for the Clark County Assessor's Office. I believe your question is, so the cost approach would be the cost approach, the same, right? But if we were testing, if they appealed the value and we were testing our cost approach, yes, if they were on one single parcel, we would look at income because we would be looking at one parcel. We wouldn't be able to separate those out and say, I mean, that this would be a single parcel. So we would value that based on income to test our value if it was on a single parcel.
Thank you.
Any other questions? Do we have a motion?
Kevin Orrock for the record. I'll make a motion that we agree with the petitioner's valuation under the income approach.
At 24 million?
Yeah, if you look at the rents, the NOI is correct. They're using a very aggressive cap, a lower cap. So I think that's appropriate. Did the petitioner can you provide a certified rent roll and some expense history to verify that income?
Yes, and a rent roll John Sullivan, a rent roll was provided in the initial appeal, but we could certainly, from that date, which I think is the end of December, could provide a certified rent roll in anything that's asked. I mean, the information's accurate and it's in the Northmark broker opinion of value as well.
So I'll make the motion to agree with the petitioner's valuation.
I'll second the motion.
Any discussion?
I have discussion. I think in doing that, because these are individually parceled, the assessor's office might need more direction on how to split out that value between 79 parcels. Just my thought. Maybe that's a question for this.
Well, I think the question that's before us is two questions. One question is the taxable value of the Fort Apache parcels in excess of full cash value. And the motion is yes, it is in excess of full cash value. Full cash value is is based on the broker's opinion of value of $24 million. And so, so I think that's E. I think that's enough. That's the issue before us, and I think we can resolve that issue. There's a motion on the table. All in favor, say aye. Aye.
Aye.
Aye.
Aye.
Thank you.
Thank you.
Great. We're on schedule. Yes. We'll break for lunch now and be back here at 1 o'clock.
Chair, would you like me to call the meeting back to order? Yes, thank you, Chair. This is Adrian Roberts Larson, Chief Deputy for the Department of Taxation. For the record, pursuant to NAC 361.686, subsection 3, a person appearing in a proceeding shall conform to the recognized standards of ethical and courteous conduct. The State Board of Equalization recognizes the following rules for hearings. Do not speak unless you have the permission of the chair. When the chairman gives you permission to speak, speak only to the members of the State Board, not to anyone else. Do not talk when members of the State Board are talking. Do not interrupt anyone. Do not speak, make noise, or gesture with your body when someone else is speaking. Do not argue with the chairman, State Board members, or the parties to the hearing. Do not speak down to, demean, or harass anyone in the proceeding or in the meeting. Do not raise your voice or act in a hostile or aggressive manner. If you want to move from behind the table, ask the chair for permission to do so. Handouts such as evidence must be handed to the State Board coordinator for delivery to the State Board members. We have a court reporter attending on Zoom who is transcribing the proceedings, so please identify yourself each time you speak. Speak clearly and slowly and directly into the microphone in front of you so that we may have an accurate record. For those testifying this afternoon, would you please stand and raise your right hand to take the oath? Do you hereby swear that your testimony during these proceedings will be truthful? If so, say I do. You may be seated. No, you're fine. Okay. With that being said, Chair, we'll move on to the next agenda item if you're ready. All right. State Board case numbers 26-128 through 26-157 relate to residential properties associated with AMH. The subject properties consist of multiple assessor parcel numbers located throughout Clark County, Nevada. AMH Director of Land Acquisition, Michael Churchfield, filed these petitions on the Clark County Board of Equalization, actions for tax years 2026 to 2027 on the secured roll. As a preliminary matter, a formal request for consolidation of SBE case numbers 26-128 through 26-157 have been submitted for the State Board's consideration. Mr. Chair.
Thank you. Would you please state your name for the record?
Mike Churchfield on behalf of AMH.
And on behalf of Clark County?
Marquise Payne for the Clark County Assessor's Office.
Melody Garfield for the Clark County Assessor's Office.
Fred Vandover, Clark County Assessor's Office.
Royal Turner, Clark County Assessor's Office.
Thank you. there's a, how many cases? 27? 27 cases.
Yes.
And it's my understanding that there are common issues in all of these cases and that you would like to consolidate them for purposes of argument, that if we resolve the issues, they can then be applied to the individual cases.
That's correct.
I'll make a motion that we consolidate the cases for purposes of hearing the common issues.
I'll second that motion. Curtis Cadwell for the record.
All in favor, say aye.
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 Aye. I'm just want to pull up my notes here. In reviewing the materials, I've identified what I believe are 3 issues. The first issue is quality class. Some of the homes in Clark County are assigned a 2.5 quality class, while others are assigned a 3 quality class. And American Homes contends that they should all be 3.5. The second issue is that is the question of whether should land be valued as a single unit or by adding together values assigned by individual parcels. Apparently, there was a decision in Washoe County that where there were where they could do a comparison and ended up applying a 10% discount to the land. And the third issue is should the full cash value of the rental community be determined as one economic unit or as individual single-family residences. Have I accurately identified the issues?
Yes, and I think with regards to the quality class, the reason we're even looking at, and it may get solved by.
I'm sorry, can you identify yourself?
I apologize. Mike Churchfield on behalf of AMH. The quality class issue is not as important as the issue of looking at as one economic unit or applying a discount to the land. Because again, if the values come down, then the quality class is rather irrelevant to us. It's only because we're looking at having to, if we're forced into this single family valuation, you know, we're not, that's where the quality class argument comes to play. But you have identified it properly.
Clark County, was my statement of the issues accurate?
I would agree. Marquise Fang for the Clark County Assessor's Office.
What I'd prefer to do instead of opening it up for you to address all the issues at once, I'd like you to identify, take them one at a time, present both sides. Mr. Churchfield, which issue would you like to start with?
I think we should start with looking at it as one economic unit. That's Mike Churchfield on behalf of AMH.
Please proceed.
AMH is asking the state board for a reduction specifically on AMH's, and I want to say this again, specifically on AMH's new development build to rent communities. AMH operates the appealed communities similar to an apartment complex, as the appealed properties are all standalone communities, okay? Where we construct and build and develop out a community that has only rental homes in that. We are the only people on title. We cannot form an HOA in the state of Nevada, just like the last petitioner, because again, AMH is building these purposely built for rentals. All the appealed communities were constructed with minimal to no options, since the end result is rental use. It's very different than a subdivision home where buyers are picking up upgrades and so forth. AMH burdens ongoing expenses such as leasing, utilities, insurance, vacancies, capital expenditures, ongoing maintenance, unlike a typical for sale community. AMH uses less expensive construction such as studs on non-load bearing walls that are 20-inch spaced. We have very limited SKUs in these homes. The executives throughout the nation, their model is to not know if you're inside one of these houses, you don't know where you are because they all look the exact same. We're buying the same flooring, same countertops, sourcing it from the fabricator direct in Thailand. So again, this is more oriented toward multifamily, horizontal multifamily development. AMH owns numerous rental homes that are in established neighborhoods that we've never appealed. Those homes can be sold tomorrow. We don't dispute that. We agree with the assessor's approach on the homes that are located in established communities where there is an established HOA, where precedence has been set that AMH could sell the home tomorrow. The homes that have been appealed before this board are all these communities that are specifically built as a for rent community. There's the Nevada Real Estate Division will not allow AMH to form the HOA, as I said before, so we are the single deed on it. Additionally, built for rent communities have a precedence of being sold for less than the allocation methodology used by the assessor. Shadow Bay, which was a DR Horton constructed build for rent specific community, sold for $411,097 per home. This was marketed on the open market, and that's what the home prices amounted to. The assessor that year applied economic obsolescence to bring the values below that sale. The following year, they pulled that obsolescence off. This is further seen on Elkhorn Point. Elkhorn Point sold for $63,925,000 in June of 2025. The assessor had obsolescence on that, which they removed this year, which it was slightly below that 63 in valuation. This year, the assessor now has it valued at $64,178,000, which exceeds the sale price from last year. That deal was on the open market, sold at a 5.75 stabilized cap rate. It was, went out to the market. We saw it at AMH. We were offered it. We looked at it. And again, this is DR Horton, who builds for sale, and they also have the for rent arm. So those are the sales that we're looking at that's indicating that we're being overvalued, and that's why we're here, because again, the sale is sold on cash flow and is sold with expenses taken into account, and it's used and utilizing a market capitalization rate. NRS 361-225 determination of taxable value states the parcel is one of a group of contiguous parcels which qualifies for valuation as a subdivision pursuant to regulations of the Nevada Tax Commission, or in the professional judgment of the person determining the taxable value, the parcel is one of a group of parcels which should be valued as a collective unit. They've brought up cases in North Carolina, which that appears to be a portion of a community. It doesn't appear to be the full community, so it looks like there could be an established HOA there. The Montage case was a for sale case where the seller was already receiving a subdivision discount, to my knowledge. There's also prior precedents with Caveata in Washoe County that's still receiving a multifamily valuation. It was built as a townhome project and is operated as a rental and would be sold accordingly, unless they were able to take the time to go form an HOA and all that, which again, if AMH were to do that, then the allocation methodology would be agreeable, because we would also burden significant costs to go into these homes and get the tenants out and the time constraint and to bring the properties up to a sellable condition, because when we do our turns and so forth, there's damage to the properties that we burden, and we're simply turning these properties and dealing with the leasing, ongoing leasing, and et cetera. So AMH's build for rent communities do not get subdivision discounts like a build for sale. So with all of that being said, that's why we're asking this board for some relief via, it could be via land reduction, it could be via economic obsolescence, but we feel that the expenses should be taken into account because there's two sales data points proving that: the portfolio sale of Shadow Bay and Elkhorn Point. There are other portfolio sales that the assessor has brought to our attention in the years previous, but they are not in one community. They're scattered out. It's just simply a portfolio sale of homes within established communities. So again, when you look at this, our average values on this particular case are anywhere from 440,000 to 506,000. The Shadow Bay sale was in 2023. I'm a licensed real estate salesperson, and cap rates and borrowing have not gotten better. It's anything, it's gotten more expensive to me. So I think that's a really good indicator of sale, and especially with Elkhorn Point being in the 300,000s last year. It further shows how these things are transacted and sold. The data is here for the assessor to simply value them based off of those two sales. And again, Shadow Bay is almost across the street from this particular subdivision or particular community that we've appealed. So that's why we're heavily weighting that $411,000 sale price. And again, we've submitted our incomes to the assessor's office. I use a 5.5 cap rate. We're coming in with a little lower values than Shadow Bay. So we're willing to agree to the value of Shadow Bay. And if the assessor can show values have gone up, then I would simply say, why not use the difference from 2023 from the allocation side to the Shadow Bay and provide us that ongoing discount until we form an HOA, and if we are to ever sell these off individually, which we have no intent of. But again, I can't stress enough with this board, these communities that have been appealed are all rentals. There is not one home in there that is for sale. These homes have never been listed. They've never been on the market. There's no intent for them to be. And as you guys can see from the submissions in there, the income and expenses were provided, and there's significant ongoing expenses.
Thank you. I just have one quick question. You mentioned the Elk Point sale and the Shadow Bay sale. Those are Nevada sales.
Las Vegas sales.
Are you aware of, these these communities that are purpose built for rental are all over the country?
Yes.
Are you familiar with how they are usually bought and sold?
Yes. I've received offering packets from Bercadia, Jared Glover, who is a Clark County licensed broker. He sends us the offering packets. It's done via income expense. It's sold based on a capitalization rate based on the income that's received, just like an apartment complex.
Have you seen any of these communities that are purpose built for rental sold as individual single family homes?
I've seen one of them convert. One of them was initially built as a for sale. They went to rent and then they went back to for sale. That's the only one I've seen. We had Aspen Vista in Reno. These two sales were from down in Clark County. They're both here. There was a sale of Aspen Vista, which was another DR Horton sale in Northern Nevada, and it sold for $387,000 per home. Again, Reno has a higher median sale price than Clark County. So it was simply based on the income that was generated off that community. It was 102 homes. And again, the one I brought up earlier where it was individually sold, they had formed an HOA out the gate because it was built as a for sale.
You also mentioned a Caveata project in Northern Nevada.
Yes, that is currently, it was built as a for sale, but it's being valued as a multifamily. I looked the other day, it's still being valued as multifamily because it's still in rental use. Every unit in there is being rented out. There's not one, you can't go buy one of them by example.
It's a townhome community?
Yes,
As opposed to single family dwelling?
correct.
Are they separately parceled?
Yes, they are.
Oh. And it's valued as a unit?
Yes.
Oh, okay, good. Good. I don't have any other questions regarding this issue of should you look at it as one economic unit? Would someone from the assessor's office like to address that issue?
Marquise Payne for the Clark County Assessor's Office. First, I would just like to address the portfolio sales that Mr. Churchfield mentioned. Petitioner.
Before you address the portfolio sales, I think the main question that we need to answer is, should we look at this as individual parcels or as an economic unit? And then once we decide in individual parcels, well, then you don't even have to bother with that. If we decide economic unit, then that becomes relevant.
Okay.
Or you may want to point to it as, I don't know, somehow bearing on this issue.
So I would just like to say Marquise Payne for the Clark County Assessor's Office. We feel Nevada law and standard appraisal practice mandates that the properties must be assessed based on their actual physical characteristics, not their current ownership, management structure, or type of occupancy. I would also like to reference that according to Marshall and Swift guidelines, these homes are single-family detached residences. Marshall and Swift defines multifamily apartments as price per building, where costs include significant common areas such as shared lobbies, hallways, central facilities. The subject property does not feature these physical components. Equalizing their value to that of a multifamily complex will violate statutory guidelines, zoning, Marshall and Swift standards, and the Nevada Constitution. We would like to present the board a case that appealed to the county, state, and Supreme Court that we feel set precedent on how to value a group of individually parceled lots owned by common ownership. This case begins on page 186. And this is Montage Marketing LLC versus Washoe County, 2018. Montage Marketing owned 376 condominium units, and 30 out of the 376 units were sold. Montage appealed on the basis the remaining units unsold should have been valued as a single economic unit. The county and state ruled that the assessor's office appropriately utilized a sales comparison approach to value these units individually and not as a single economic unit. On page 200, the Nevada Supreme Court upheld the county and state board's decision referencing NRS 361.227, paragraph 5, and stating, county assessors must use valuation approach that most accurately measures the full cash value of property with any consideration of the owners, without any consideration of the owner's identity or intent behind the purchasing property. Montage's status as an investor does not warrant valuing its condominiums differently than those of other owners. To hold otherwise would result in a determination of the condominium's value and as an investment, or their value to the current owner and not the full cash value, which is the price that each condominium would receive on the open market. Valuation must be based on physical characteristics, not occupancy or ownership. Article 10, Section 1 of the Nevada Constitution requires a uniform and equal rate of assessment and taxation. If a family-owned, owner-occupied, single-family detached residence is physically identical to a corporate-owned, tenant-occupied, single-family detached residence, they must carry the same taxable value. AMH's status as an investor does not warrant valuing its single-family residences differently than those of other owners. Granting the petitioner's request to value these properties as an artificial multifamily apartment development would establish a preferential, unconstitutional dual-class assessment system where corporate owners of rental properties are valued lower than individual homeowners for the exact same real estate.
Thank you. Do you want to add your comments on those Elk Point and Shadow Bay sales?
Sure, thank you. Marquisa Payne, Clark County Assessor's Office. Yes, the petitioner has referenced two bulk lot sales of individually parceled rental communities sold as a portfolio. The first sale from DHIR Las Vegas 1 LLC to SFRV Tranche 5 Borrower LLC, referred to as Shadow Bay, occurred on July 31st of 2023 and sold for $48,098,361. The petitioner is comparing the sales price from July 2023 to the 26-27 taxable value, which is not the valuation year in which the sale occurred. A sale occurring in July of 2023 should be compared to the valuation year 24-25. The assessor's total taxable value for this Shadow Bay community for the 24-25 fiscal year was $46,228,350, which was $1,870,000 below the sales price. The second sale from DHIC Tully 1.06 LLC to Elkhorn Point Owners LLC, referred to as Elkhorn Point, occurred on July 25th, 2025 and sold for $63,925,000. Although, excuse me, although appropriately compared to the 26-27 taxable value of $64,178,226, this sale was for an attached townhome community, which is different than the homes in this appeal, which are detached single-family residences. In addition, the total taxable value for this community is $253,226 above the total sales price, which represents 0.39% difference from the 26-27 total taxable value of this community. The assessor's office believes this does not indicate that the AMH communities are overvalued.
Thank you. Are you aware of any of these purpose-built for rental communities and any other sales of communities that are specifically built to be rental communities?
Marquise Payne for the Clark County Assessor's Office. No, these are the only two sales that we were able to find the last few years that included portfolio sales for one community. We did have other portfolio sales, but they weren't confined to one community. They were kind of spread all over the county.
Right. Are you aware of any communities that are purpose-built for rental that have been then broken up and sold as individual single-family dwellings?
Not that I'm aware of. I believe there was one community, but I can't be positive on that, so I'll say no.
Okay. I think on this issue of whether we should look at it as one economic unit for determining full cash value. I think this is the issues are very similar to what we addressed in the prior hearing. I think that it's my understanding these is although it's individually parceled, they cannot be sold as individual parcels. They're, it's unlike the Montage case where the developer was in fact marketing them for sale. was in fact selling them during the tax years at issue. They actually continued to make sales. It's my understanding that in this case, these are purpose-built for as standalone rental communities. And the evidence appears to support the fact that when they're bought and sold, they're bought and sold as purpose-built rental communities. They're not bought and sold as individual parcels. So I would so I believe when you're determining full cash value, you should look at it as one economic unit. I do not think there is a legal prohibition to doing so. NRS 3612272 indicates that the unit of appraisal is a single parcel unless you meet one of the exceptions. And I think that in the professional judgment of the person in determining the taxable value, the parcels are a group of parcels which should be valued as a collective unit. So that would be my position on the first issue. Do any of my fellow board members have comments?
I do. Corey Burke for the record. I just actually had a couple of questions for Mr. Churchfield, which I think might help solidify your comments, Chairman. Are the streets in this community, are they private or public?
We deed them, it depends on the community. We deed them back usually to the city on some.
Okay.
It depends.
Okay. Have these ones been deeded back or are they still private?
I don't know off the top of my head. I'm assuming they're probably public on this
Alright.
community.
And then are there other amenities in this community, swimming pool or playground or anything like that?
I don't know off the top of my head on this one. We do have at one of the other communities in Las Vegas, we do have a community center for the folks with like an apartment complex.
Right. And then you've mentioned a couple times that you cannot form an HOA. Does that mean
Right.
ever?
No, we could at a later date with a further expense, and I don't know how much time delay it would take, because again, our intent was to build these out with very minimal options because they're all the same essentially. So while we could, it's not the intent, and it'd be at further costs. I don't have the costs because we haven't gone down that road, but we would have to talk to the ombudsman. We would have to form the HOA because we cannot find ourselves currently. The rules and regulations are done via the lease because we are the single deed owner.
Okay. So based on that, your take is that it would not be legally permissible to sell these individually?
Not at the moment.
Okay, thank you.
Kevin Orrock for the record. No, I agree with your comments, Chair. These are communities that are built specifically for rentals. And so it should be looked at as one economic entity.
I'll second that motion.
Any comment? All in favor, say aye. Aye.
Aye.
Aye.
This is Carrie Skalsky for the record. I have texted member Burke. She cannot hear us. She's going to log off and log back in. She did indicate to me via text that she voted aye in favor. Thank you.
Carrie, I can hear you. This is Corey Burke. I could not hear anything else since the vote, though.
Can you hear me?
I can hear you now.
Okay,
I'm
so
not
we're
sure
back
what
on,
happened.
And you voted aye in favor of the motion as well. So the motion passes unanimously.
Okay.
I'd like to move on to the second issue.
Okay. And it may not be an issue if we value it using the income approach. So I don't know what the results.
Well, the second
Oops,
issue
I'm
for
sorry.
me,
Mike Churchfield.
the second issue for me is whether this paired sale in northern Nevada provides a basis to provide a discount, and I'm just curious how it was applied in Washoe County, and then the Clark County can respond and say why that is an appropriate way or is not an appropriate way to do whatever they did.
Absolutely. Mike Churchfield, AMH. So again, thank you. And I would like to remind everybody, this is annual reappraisal. So again, if something ever does happen later, the assessor can change the value then. But the way that both the Carson assessor and the Washoe assessor have approached this is they've taken the difference between like a normal D.R. Horton tract individual home, like three of those sales average amount, and I'm going to use simple math right now. And so if those averages were at 440,000 and then the sale in Reno of Aspen Vista was at 400,000, they applied a 10% downward adjustment to the land. Vegas could apply it via obsolescence on annual review per the income approach, which I think would be preferred here, because they've applied obsolescence to things like Shadow Bay and Elkhorn Point in the past. And that also gives them the chance for us and them to submit incomes annually because again, income and expenses change.
Could this is based on the Aspen Vista sale?
You're correct.
Could you please explain what that transaction was?
Yes.
And apparently there was a neighboring transaction.
Yes. Aspen Vista was sold for, it was 102 homes. It sold for like $387,000. And there's a community directly next door to it that's a build for sale D.R. Horton community. And those homes were selling, in the lower to mid fours. So the assessor determined that average of what the individual homes were selling for, determine that price, and then determine the average price of the portfolio sale, because it was all one thing, and applied the difference via the land as a percentage discount to the land value, because they're still using allocation to derive the land value because it is individually parceled.
Mm-hmm. Okay, thank you. Clark County, would you like to address this issue of using a paired sale analysis like that to establish a discount?
Marquise Payne with the Clark County Assessor's Office. We do disagree with that. The only bulk holding discount for valuation that's available to a developer is under the criteria of a qualified subdivision. Nevada law under NRS 361.227(1)B and NAC 361.117 grants a provision for temporary relief provided during the developmental phase of a subdivision. This allows for a subdivision discount to account for the absorption period of vacant residential lots NAC 361.1295 gives guidance that a subdivision is considered fully absorbed when less than 10 parcels held under common ownership are not sold, rented, or occupied. Once a subdivision is considered fully absorbed, they no longer meet the criteria for the subdivision discount to the land. The Blue Vista community, as well as the communities included in the other consolidated AMH cases, have been fully absorbed and no longer qualify for the temporary subdivision discount provision under Nevada Administrative Code.
I appreciate that when calculating the initial taxable value, you should follow that regulation and for qualified subdivisions. But when you're determining full cash value, a paired sale analysis is a common technique used by appraisers for determining a time adjustment, different factor, a paired sale analysis. And what the, and I think from the testimony here is that Washoe County and Carson City assessors are using this not to establish the initial taxable value, but to determine whether, to determine full cash value. And they're looking at it as a paired sale analysis, which is a normal technique. So,
Mr. Bancroft,
Yeah.
I'm Stephanie Jones with the Clark County Assessor's Office. So just talking about that sale in Washoe, I believe the sale was in 2022 because I did, was it in 23 or 22? Okay.
my notes indicate 2023.
Okay.
So I
Okay.
can understand you're saying
Well,
it's dated.
Not just that, but we don't know the particulars of the sale. Like, we don't know what the size of the homes were in the neighboring communities. We've never been furnished that kind of information.
No.
So it's hard to say, whether just taking this community and comparing them to each other without knowing the particulars, the ages of the homes, the size of the homes, the quality of the
No,
homes. So I just wanted to put that on the record.
No,
And
but that's a legitimate concern.
Okay. And then just one other thing, here in, also that's in Reno. I understand we're all in Nevada, but that is a different market. So here in our market, we did just discuss the two sales that the petitioner had brought up. And comparing those sale prices to our taxable value for the related year does not indicate that any of them sold for more than our taxable value. I'm sorry, the one sold for 0.39% more than our taxable value in the fiscal year that's relevant. So, again, he brought up the Shadow Bay and that he was comparing that to the wrong year. So that's all.
I was just interested in this paired sale analysis that Washoe and Carson City did. And the initial response was that it's not supported by statute because we only have this qualified subdivision methodology. But you've clarified it that paired sale approach that Washoe and Carson are doing is a legitimate approach, but taking that and applying it in Clark County may not be appropriate because of the time frame and not understanding the particulars of the transaction.
May I just say one other thing? I believe that, and correct me if I'm wrong, I believe that they are using that to set their taxable value, not to test their value. I believe that adjustment is being applied to those homes when they set their taxable value.
So are you suggesting they're doing it wrong?
No, I'm not suggesting they're doing it wrong. I was just clarifying that they were using that to set their taxable value. They're applying that adjustment to set their taxable value, not to test for market value.
But you're suggesting that that's okay.
No, I'm just suggesting that I believe you commented that they were using that as a test for market value and then applying that when testing for market value. But I believe that's part of their taxable value when they're setting their taxable value. So even if not appealed, they would be getting that value as part of their taxable value. I was just clarifying that. I'm not saying it's incorrect. I'm just.
Thank you. No, I tossed that. I read through the materials and identified that as an issue I wanted to learn more about. I don't think it's an issue we need to resolve at this point or make a vote on. The final issue was this question of Marshall Swift and how the quality class is being applied. And I think it is important that we address that issue because in your materials or in your presentation, you mentioned that Washoe and Carson are doing it one way, different than the way it's done down here.
So I want to clarify 2 points. One is you going.
Can you state your name?
Mike Churchfield, AMH. The values are not being set off this 10%. It moves, our values move up annually, and that's still the amount being applied because, again, allocation changes every year. And they are model match homes to the sister community. So it's not, we're not comparing mini homes or things of that nature. I wouldn't do that before this board. And I have I've been very honest with your office thus far. I think you would attest to that. The quality class issue, the assessor's office does not differentiate in a subdivision that's for sale quality class differences in a tract neighborhood. They establish one quality class. That is, so the most upgraded home is getting off the easiest. The guy with the most minimal upgrades is paying the most. So what we've done is we build the same interiors on every home, whether it's in Florida, Nevada, Tennessee, wherever. The only differentiation is per municipal requirements. They require different enhanced front elevations sometimes and et cetera. So that's where the assessor is using those front enhancements and saying that's a quality class upgrade per se. We're still building these homes on non-load bearing walls with 20-inch studs. We're trying to go to aluminum wire in these homes. These are homes, again, with no options. So they're built at a cost point that is less than a builder who's building individual homes per each buyer that are going to have upgrades. No matter how you skin it, there's going to be upgrades in that community. So you have differences in one tract community that I've shown that can be $1 million spread. So all we're asking is we're a 2.5 in Washoe, we're a 2.5 in Carson. A lot of the communities here are 2.5s. We would like it equalized to 2.5 because, again, the interiors of these homes, the backyards, they're all the same. Again, there is minimal in front enhancement. Some homes have a small rock facade by the garage and so forth per municipal requirements and per different designs to the areas we build. Some areas require garage dominance, et cetera. So we have to articulate our plan just a little bit, but that's it. They're minimal kitchens, et cetera.
Do you use the same plans
Yes.
in Washoe County that you use in Clark County?
Yes, we use a lot of the same plans. We have a book, we have a catalog that consists of probably 40 plans, give or take, because we have a 25-foot series, 30-foot, 35, depending on the lots. A lot of those plans are shuffled throughout the nation.
And in Washoe and Carson City, when you build on those plans, how do the assessors up there apply the quality class?
They're applying us as a 2.5. They've walked through all the communities. They see the consistency. And so they have not differentiated quality class because, again, per our conversations, they know it's the same plans, it's the same kitchen, same everything being built. You may have a little differentiation on the front, but that's it.
Do the communities in Northern Nevada have differentiation on the front?
Mm-hmm.
Different enhancements?
Yes, some have Hillsdale Corner, by example. There's some stone on it because it's in City of Reno, which is more stringent on requirements than Washoe County per se. Washoe County, we've eliminated some of that because, again, they don't require it. It's simply a municipal requirement. That stone work, I mean, they can say, oh, Marshall and Swift, for quality class, you can differentiate like 50,000. Well, our cost on that stone is very minimal. I mean, it's $1,500 or something because we're buying in such volume.
Doesn't anybody have questions of Mr. Churchfield on this quality class issue? I'll move on. Does somebody from the assessor's office wish to address the quality class?
Melody Garfield for the assessor's office. That is something that we've looked at the last several years. And as you've mentioned, there are some amenities that are on the 3.0 homes that are not on the 2.5s. The difference may not be substantial. It ends up being like $16,000 to $20,000 per home. But many roof cuts, we have it in the case file. I'm sure you've looked at it, all the differences between what we consider a 3.0 and a 2.5. I can go into those again if you'd like. But I'm looking at the rents for the 2.5 and the 3.0 neighborhoods as well. And when I look at
Well,
a similar neighborhood, it looks to me that they rent higher as well.
Well, that gets away from the point of what quality class should be assigned. I'm particularly interested. Can you point me where in the materials?
On page 240. On page 240 in the case file, there's 2.5 homes.
And this is in case 26-1-130? What page?
240. 240. So these are homes that are, we consider 2.5s. You can see that the roofs are very square. The windows are flat, no pop out.
Can you state your name?
Melody Garfield for the assessor's office. And on the next page, as an example, is a 3.0 home. There's a lot more cutouts on the roof, more stonework. There's arches instead of rectangular cutouts. And like I said, the third picture even has corbels on it, and it's, to me, it's very obvious. But I've been praising for a long time, and I can see these differences pretty obviously. And like I said, it's not substantial. It's $16,000 to $20,000, but it is a difference that we note.
It's not about the money. For me, it's about the uniformity. Part of what we're charged with is making sure that valuations throughout the state are done in the same manner. And if you're looking at this and saying it's a 3.0, but Washoe is looking at it as a 2.5,
Stephanie Jones for the Clark County Assessor's Office. Ms. Widener and I did meet through Zoom with the Washoe County Assessor just to talk about this issue and talk about their quality class. We did show them, they showed us pictures of their homes there that they're 2.5 quality class, and we showed them basically what's in the packet there. They did say that, the 2.5 homes are similar to what they have there, but they didn't have anything like the 3.5 homes that we showed there. So we have a lot more communities than they do. I'm not sure how many Carson has, and I'm not positive how many Reno has, but we have quite a few of these communities here. And some of these areas that these communities are in here do require certain things to the exterior of these homes. So they are a little different than the 2.5 homes. And I mean, again, this is just going off of the conversation that we had with Washoe County, that they also acknowledged that our 2.5s were similar to their 2.5s, but they did not believe that they had any homes that were like our 3.0. And we did go out and visit every single one of these communities. We took pictures. We came back, we met as a team to see whether, what should be a 2.5, what should be a 3. Sometimes there's communities that have a little of both, and we have to make a determination what's the majority of the homes in there, because we do want to value the homes in that community the same. So, but I just wanted to let you know that that was the discussion we had. I haven't seen the houses in Reno besides the pictures they showed us, but that was just a conversation.
thank you. I'm glad you had that conversation with Washoe County. That's reassuring. One of the assertions is that the assessor's office applies one quality class in all neighborhoods. That I took that to mean that like if DR Horton were building a neighborhood, that you'd apply one quality class to all the homes built in that neighborhood. Is that true?
Not every neighborhood. Very often for the developer, there are neighborhoods that we do use the same quality class throughout. And there may be, like Mr. Churchfield said, there may be minor differences between them, but we have neighborhoods that can range from 3.5 to 6.0. I mean, it's not something that is set every time we appraise a neighborhood. It all has to be the same quality class. We do vary sometimes in neighborhoods.
Mr. Churchfield, would you like to comment on page 240 and 241?
I don't have it in front of me at this time, but again, what I would say is they're referencing custom neighborhoods. That's very different than a tract neighborhood. I specifically said tract neighborhoods are all one quality class to my understanding, which I've seen in Vegas. So again, we've seen $1 million spreads in a neighborhood, whereas they're talking about these little things with us and being differentiated from Reno. Reno, we have to deal with frost lines on our foundations that are above and beyond the cost of Vegas. So again, they may not be able to see these things, but again, we deal with snow up there. So your roof has to be designed for snow and all those sorts of things. It doesn't have to be down here. So again, what I'm looking at is your typical tract neighborhood. They do not differentiate quality classes in a typical tract neighborhood. We did not in Reno, and I do not believe they do here. And again, you can have, from an upgrade standpoint, you can have $1 million swings in any of these neighborhoods.
Okay, thank you. Does anybody else have questions on this quality class? I may have gone too deep into it. I think we've resolved the main issue, which is it valued as an economic unit or not? We've heard them talk about this paired sale in Northern Nevada and the application of Marshall Swift. I think we've dealt with the issues that could be common to all these cases. Am I correct? Would anybody like to add anything to this?
The only thing I would add is when it was brought up about the Elkhorn Point and Shadow Bay, the assessor has not discussed the obsolescence that was applied to those communities. Those communities, the year of the sales, obsolescence was applied. They're saying in 2026, oh, it's slightly over. Well, they had obsolescence on it last year. What if they provided it to them? It seems like a logical approach to provide it to us as a means, since the board has agreed to look at this as one economic unit. It seems that obsolescence is the easiest vehicle to bring the values in line, because the assessor here has a precedence of doing that, as seen on Shadow Bay and Elkhorn Point.
Thank you. Does Clark County have any final comments on these common issues between the?
Just regarding the obsolescence, we reviewed.
What do you mean by obsolescence?
I'm sorry, I thought we just brought up the obsolescence issue. Okay. We do review these communities every year, like we do every other single family community, condominium community, townhouse community, to see if any obsolescence is required. And even on some of these cases that have come before you today, we have obsolescence on some of these homes for this year. So every neighborhood is different. It depends on the comparable neighborhoods, what their median sale price is compared to what our taxable value is. And so we have made obsolescence adjustments. Sometimes we made some last year, some neighborhoods we took that off this year, other neighborhoods we added on this year. So I just wanted to say we didn't exclude them from that analysis.
I'm sorry, your microphone is not on. I can't hear you.
Speak up.
Can you hear me now?
No, your microphone is off. Can you use a different microphone? That microphone's not working.
Kevin Orrock for the record. So give me an example. Obsolescence. What do you mean by that?
So
Because
we,
there's functional and economic.
yes.
So
So we look at the neighborhoods to see if our taxable value in these single-family homogeneous neighborhoods, we look for the median sale price in the neighborhood, and we compare that to our taxable value to make sure we haven't exceeded market value. And we will apply an adjustment to bring it down below market value on a mass basis in each neighborhood individually. So in some of these neighborhoods, like for example, I don't know if case 130. For example, in this fiscal year, some of these neighborhoods have been given an 11% obsolescence, which means that we've reduced the improvement value down 11%, added that to the land value, and that puts the value in the neighborhood under what the sales, just slightly under what the sales are selling for. And we do this analysis every year using the prior year sales. So, that can change from year to year as the market goes up or down. So like I said, some of them had obsolescence last year applied and didn't this year. Some of them didn't have obsolescence last year, but do this year. So again, we individually look at each one of these neighborhoods like we do every other single family neighborhood for that reason.
So when you do your sales approach, it was higher than what the actual sales were?
Yes, our taxable value that was set were higher
Higher,
than,
okay.
and so we've adjusted the improvement values down to be below what the market value would be for home sales.
Okay.
Even we use comparable neighborhoods to do this analysis for
Okay,
these
thank
type of,
you.
yes. And I just want to make sure as we proceed that we'll be able to talk about our income approach if that's the method that if the board is going to use one single property income approach. 'Cause
Love you to let me get to that.
Okay, I was just double
Yes.
checking. Okay, thank you.
We've addressed or looked at the issues that were common to these cases. And now we have to come up with the valuation for them. There's 27 cases. Do you want us to, should we, the case we've kind of been looking at right now is 26-130. Should we make a decision in that case and then decide whether or not that decision should be applicable to all the cases?
Kevin Orrock for the record. Yeah, I think that's a good way to look at it.
Okay, so.
Mr. Bancroft, that would be
Please,
that would be okay.
please, it's not your turn. One thing that really irritates me is the way you all interrupt everybody. There's got to be some order to this. You've got to wait until it's your turn. We're going to look at case 26-130. I'm going to give both of you an opportunity to address how this property these parcels should be valued, assuming it's done as one economic unit. And we have time. This morning went quickly. So, Mr. Churchfield, would you please explain to us what you believe the full cash value of this property is?
Yeah, so this is I want to make sure I'm correct because we consolidated. This is for Bella Luna, correct? Or is it Cactus? Which one? Blue Vista. Okay. So for Blue Vista, when we ran the income approach on it, we're coming up with a value of $401,278. And that income approach was added to the petitioner packets. And we did it very simply. We used the Elkhorn Point sale. It was a 5.75. We ran our numbers at 5.5. capitalization rate. We think this is better than JRM because these things are sold via a capitalization rate. We didn't load the taxes into it because the brokers don't sell the things like that. They offer it with taxes included in it. And that's why the 575 was reported. So with that being said, that's how we came out to the 401,278, and it's in the packet on the income approach.
I'm sorry,
Uh,
your microphone's not on.
I apologize.
I'm working off of the spreadsheet I have here that I've put in this, that I consolidated down all the income approaches just to kick out the value for each one.
So if I'm understanding this correct, in case 26-130, Blue Vista, the taxable value is currently 48,525,992. And which is 462,152 per unit. And you're proposing, well, first of all, how did you calculate your NOI?
We took the income off the property that we received, and then we added in the expenses. We did not add in debt or anything of the nature. We just add in the typical expenses. Arrived at a net operating income, divided that by the capitalization rate of 5.5 to yield the value.
And
these are all the ones on the, let's see, it was the petitioner's brief. I only went for the stabilized ones. If they're unstabilized, it's too low of a value because again, we're building those communities out. So I wanted to make sure and illustrate that we're only looking at stabilized.
So I'm just. Clark County, do you know which page his summary of that is in the record on appeal? Yeah, I'm almost there. Good. Thank you. On page 52, and this is, what do we say? Blue Vista. Is it? Yeah, 130. Blue Vista. And I don't see a well, what I see, and Mr. Churchfield, you may not have this in front of you, but it's a one-page chart that's titled AMH's Income Approach to Value. And it shows all of the individual communities. And some of those, three of those communities do not have any information, one of which is Blue Vista.
I know I submitted the trailing 12 and an income and expense on it, and it was all done via the T12s that were submitted last year. I apologize. I don't know where it is, but I'm looking at on the brief I did, I simply took the numbers from all the T12 income approaches and just put them in the Excel spreadsheet. So that's how I was deriving the 401,278.
So it's in your brief?
It's the summary is.
Yeah. Okay. So
sorry, a lot of cases.
Oh. Okay, what page? Easy. It's only 3. Blue Vista. So you've got the value per unit there. But what is the
overall, may I grab my calculator?
Yeah.
Thank you.
Yeah.
The overall value that I came up with on Blue Vista is $42,134,190. And the way I established that was taking the 401,278, and I know that there's 105 parcels in that community and just multiplied it.
Yeah. And so, you essentially are basing yours on a stabilized income and then applying a 5.5% capitalization rate.
You're correct.
Okay. Clark County, would you like to address the valuation, the full cash value of this?
Mr. Chair.
Yes.
How are you doing the ones that aren't stabilized?
Right now, I don't really have I don't have a value for them per se, other than,
Value in here.
yeah, those were just, I ran just the T12 and divided it out. So I wouldn't consider it.
Realistic?
It's not, because it's not stabilized yet. So as you can see, I crossed those out because they're too low values. It's too low of an indicator.
Well, I'm looking at Cactus Cove. And you've got a home value of 317,807.
Yes.
When you just divided the numerator by 49 times.
Yes.
Whatever the numerator was.
You got it.
Yeah, just NOI.
Yeah.
Existing NOI.
Yep, exactly. It's T12 at that point.
Thank you.
Clark County, would you like to proceed?
I'm sorry, I can't hear them. Still can't hear them.
Melody Garfield, Clark
Thank
County
you.
Assessor's Office.
I can hear you now. Thanks.
Okay, great. Thank you. Our cap summary is on page 179. And we did use the rents. So I think maybe our income is going to be similar to Mr. Churchfield's. Again, when we prepared this material, we did not think we'd be looking at it as a single entity. So we didn't put a lot of weight on this methodology, but I did use their market rents the rents that we could attain. And so we used a 5% vacancy, which is what we showed market data supported a 5% vacancy. We added 10% for other income. And that then we had an effective gross income. We had expenses of close to 8,000 per home. And that gave us a net operating income. And on this page, that number is about 2.5 million. We used a 5% cap rate because that's what our market data indicated. And so that gave us a value that we then divided the units into. Again, our value for an average value for each of the homes in here is about 462, as you stated originally. And using our cap summary, we have a value of about 476 for each unit, which is higher than our taxable value. So we felt that even this cap summary as a single entity supported our taxable value and didn't warrant a reduction.
Did you have the income and expenses from the property when you prepared this?
I have my file with all the income and expenses that I received. I did not find it in the case and I do not have it in my file, so it may have
but-
gotten misplaced.
But you had it when you prepared this.
I didn't have it from him. No,
Oh.
but I used the rents that I could find online that are for this property.
Mhm. Any other questions?
Yeah. So the county is using 75 basis points lower cap rate than petition. You're using 5, he's using
5.5.
quarters, or you're using 5.5.
Yes.
So 50 basis points difference. And you have a $75,000 differential per unit.
You mean in
He's got
expenses
401, you got 476. Is that what?
per unit? I'm sorry. Oh, price per unit?
Yeah.
Yes, I have 470. I'm sorry, 476 is what our income approach shows.
Right. And he shows 401.
It's a big difference.
Part of that is you're using a more aggressive cap rate,
I have support for that in the case.
which is very nice of you to do that because give them a higher value, but your income, the two incomes have to be, your NOI's got to be significantly different. And it's the only way you could get that differential.
Well, yes, I like I say, I used market data other than the rents. The rents are his rents. So do you have your PGI, Mr. Churchfield? I'm sorry, I don't know if I'm allowed to ask that question.
Yeah, if you're gonna go down this path, it's almost like he's gotta give you a certified rent roll and an expense statement. in
Which
one or
is
2
something we
years,
request.
So that guys are both working off the same NOI.
That's been provided, is provided at county. I don't know. I can pull up my laptop and show the submissions. It was provided at county board to hear that they're disputing what was submitted. It's in the record. Sorry.
I'm sorry, I can't hear you.
Mike
I can't.
Churchfield, AMH.
I apologize to the recorder. I was just making a reminder, this is Adrian Roberts Larson for the record, that there's a lot of back and forth and that it's making an unclear record. So I need each time you speak to state your name, even if it's just a back and forth between two of you at the chair's discretion. Please make sure you're stating your name. Thank you.
Kevin Orrock for the record again. So you gave the county NOI statement or?
A trailing and Mike Churchfield AMH at the submissions of all of our county appeals. We submitted T12 income and expense data for each complex and did an income workup on each one. I have my laptop right there. I could hook it up and probably get those files, but they've been provided. It's in the county record. I saw it earlier, and I think the appraisers would acknowledge that that was sent, that was part of the county packet.
Marquis Payne for the Clark County Assessor's Office. He did provide T12s for certain communities, but they weren't provided for all communities. And it appears that they were not provided for Blue Vista, which we're talking about right now.
We just, that picked the wrong community to start with.
Sorry to interject, Mike Churchfield AMH. It's a little confusing, and I apologize for this because the assessor sometimes uses like streets versus the community name. So Hualapai and Oleta is the same as Blue Vista. So it's the data, it should be there for Hualapai and Oleta because I did have a value kicked out on it. It was submitted. That Hualapai and Oleta is Blue Vista. That's like the cross streets to it. Is that? It should be whatever one is 105 parcels. That's it then. I know I provided it. May I grab my laptop? I can pull this up in 2 seconds.
Why don't we take a 5-minute break?
Okay.
Mr. Churchfield, were you able to identify your stabilized NOI for the Blue Vista property?
Yes, Mike Churchfield AMH. For Blue Vista, the stabilized NOI was $2,317,382.
And Ms. Garfield, is that correct?
Melody Garfield for the record.
Yeah, what NOI?
My NOI is 2.5 million.
So a slight difference there, and then the difference in the cap rates. About $200,000 difference in the NOI.
Mine are actual expenses. They alluded that they were using market expenses.
Right. Would you like to comment on? Some people might suggest you're just a poor manager. Would you like to comment, are expenses higher than market on this property?
It's so dependent on numerous factors. We cannot control tenants. We cannot control theft. We cannot control a lot of things. So one thing that's very unique about AMH is we do not have on-site leasing. It's leased. We have a centralized leasing place, and it's self-accessed entry, which we're working through because sometimes we'll come in the morning with no appliances or things of that nature. And then we have tenants that do a lot of damage. We can't bill them back for some of the damage that occurs. We're pet friendly. That affects us a lot on turns. A lot of time we're replacing flooring, et cetera. So the other biggest component is property taxes.
Mm-hmm. Well, I'll just toss out there my thought on resolving this case. It would be to apply a income approach to determine full cash value, utilizing the assessor's market-based income and expenses, but increasing the cap rate to 5.5%, which I believe is still, I think the market currently would probably be higher than that, but increasing it to 5.5%. I believe that by doing so, it would reduce the per unit taxable value to 433,382. Any other board members have thoughts?
Just Kevin Orrock for the record. What was the county's taxable value on a per unit basis for that?
For this,
Mhm.
yes, Melody Garfield for the assessor's office, our imputed value, taxable value per unit is 462,152. And just to be helpful, if you could give us a total value, because these are a variety of sizes of homes. And so we want to be sure we're being fair and instead of like a per unit value, if you could just give us, based on that per unit value. Very good. Thank you.
So what is the total value, taxable value for this stuff?
The current total value is 48,525,992. And I will make a motion that value be reduced to $45,505,091 using an income capitalization approach that utilizes the income and expenses presented by the assessor's office, but applies the higher 5.5% cap rate.
Curtis Cadwell, I'll second that motion.
Any discussion? All in favor, say aye.
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 Aye. The motion passes unanimously. Now, for purposes of the remaining 26 cases, is this an approach you're comfortable with applying to the rest of the cases?
Curtis Cadwell for the record, yes. I would say we apply it to all.
Kevin Orrock, for the record, I agree.
I believe that there is an assessor's capitalization analysis in each one of the cases. And all you would need to do is go in and apply the 5.5% cap rate. The one exception being case 26-157. I could not find an income capitalization approach in that case. Ms. Garfield, could you pull up that case and tell me if there is one?
I'm sorry, Mr. Chair, could you just give me the neighborhood name as well?
Corey Burke for the record. I think it might be Tropical Vista. Does that sound right? Mike?
Yes, it is Tropical Vista.
Correct. Mr. Chair, 157.
26-157.
So, page 78 is state. No, no, we're talking about page 157. It's not at 157.
If we know that their expense ratios, maybe we can expedite this by using, I don't know if they're using, okay.
Just be patient.
If somebody's speaking on
Sorry, Melody
microphone,
Garfield.
okay.
Melody Garfield for the assessor's office. I do have the cap summary here. I am not seeing it in the case documents where it should be anyway.
And what was the NOI that you used?
The NOI I used here is 2.2, I'm sorry, 2,227,226.
At a 5 point, well, first, at a, pardon me. At a 5% cap, that suggests a value of 44.5 million. Is that what you came up with, Ms. Garfield?
Yes.
At a-
Melody Garfield for the record, 44,544,510.
At a 5.5% cap, it comes out to $40,495,018. So so I'll make a motion that we resolve all the pending appeals by utilizing the assessor's income and expense approach, but substituting a 5.5% cap rate to the final ballot, to the final NOI, with the caveat that for case 26-157, the value be calculated using an NOI of $2,227,226.
I will second that motion.
Any discussion? All in favor, say aye.
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 Aye. Thank you. Chief Deputy Robert Larson, will you introduce the next item?
Yes, just one moment, Chair.
Mike Churchfield, AMH. I just want to thank everybody at the assessor's office and everybody for attending today and for hearing our case. Appreciate it.
Adrian Roberts Larson for the record. We would be moving on to item agenda number 6. This is the briefing to and from the board and the secretary and staff for possible action, proposed hearing schedules and docket management. Chair, the next state board meeting is scheduled for Wednesday, August 26th. That meeting will be held at the Department of Taxation's Reno location. We received 14 timely filed direct appeals by the May 15th deadline and 1 timely filed agricultural direct appeal by the July 15th deadline. Of the 14 timely filed direct appeals, 4 have been withdrawn. State board case numbers 26-167, 26-169, 26-172, and 26-173. The 10 remaining direct appeals pertain to property in Washoe County, and 4 of these have submitted proposed stipulations for the state board's consideration at the August state board meeting. Those are state board case numbers 26-160, 26-162, 26-165, and 26-168. The agricultural direct appeal pertains to the Nevada Department of Taxation and involves property in Douglas County. Included with the meeting materials for this item is the 2026 State Board of Equalization updated docket. Deputy Attorney General Dana Cook will now provide an update on the pending petitions for judicial review from the 2025 State Board session. Thank you.
Before we move on,
Yes, Chair.
what are the dates for the October hearing?
Chair, I'm going to defer to Carrie Skalski.
This is Carrie Skelski for the record. For October, we have tentatively scheduled the 14th and the 15th in Las Vegas.
Thank you.
Thank you, Carrie. Over to Dad Cook.
Dana Cook from the Attorney General's office for the record. The following is the litigation update from the Nevada Attorney General's office as to petitions for judicial review in the district courts throughout the state of Nevada. Okay, when the annual session of the State Board of Equalization began in March of this year, we had 7 pending district court cases. Since then, 2 cases were dismissed for jurisdictional reasons. The update covering the remaining 5 cases is as follows. Esmeralda County versus Esmeralda County School District. It's State Board Case number 25-143. A briefing by all the parties was completed on July 9th. No hearing has been requested or set by the court at this time. Next case is Clark County versus Townsite Solar Aravon LLC. State Board case numbers 25-139 and 25-140. Briefing by all parties was completed on June 15th. The hearing is currently set for September 22nd, 2026. Eagle Shadow Mountain Solar versus Clark County, State Board case number 25-155. Briefing by all parties was completed on June 2nd. On June 30th, the court notified the parties that it has not determined whether a hearing will assist the court, so no hearing has been set at this time yet. Carmona versus Lyon County, State Board case number 25-109. We filed a motion to dismiss in this case. On June 5th, the court issued an order dismissing the appeals for tax years 2022, 2023, 2023, 2024, and 2024, 2025. However, the court did not dismiss the appeal for tax year 25, 26, for which the petitioner did not appear for the hearing at the state board. On July 23rd, based on the court's concerns, I filed a motion to remand the 2025-2026 appeal back to the state board for an opportunity for a hearing on the merits. We are awaiting a ruling on that motion. The next case, Clark County versus Chada, State Board Case number 25-125. Briefing by all parties was completed on July 15th. The hearing took place soon thereafter on July 21st. We don't have a written decision from the court yet. However, at the hearing, the court did not find error with the use of sales ratios in determining inequity under NRS 361.356. However, the court is remanding the case for the board to address the reduction on the stated basis of obsolescence. More to follow once we get a written decision. I don't want to lean forward too much right now since we don't have that. But that was what I could glean from the court's statements at the hearing. And that concludes the litigation update.
Thank you. Do any board members have questions about the hearing schedule or any of the cases currently in litigation? If there are no comments, Chief Deputy Robert Larson, can you introduce the next matter?
Yes, Chair. Adrian Roberts Larson for the record. Agenda item 7 includes for possible action, review and approval of the June 4th, 2026 State Board of Equalization meeting minutes.
Members, I hope you've reviewed the minutes. Do you have any corrections or comments on the minutes as presented?
Make a motion to approve the June 4th, 2026 meeting minutes.
Second.
We have a motion and a second. All in favor, say aye.
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 Aye. Motion passes unanimously. Could you introduce the next matter, please?
Adrian Roberts Larson for the record. Agenda item 8 provides an opportunity for comments by the state board members.
Does anybody have comments? No? Proceed. Public comments next. Denise, can you please read the public comment language for the record?
Yes. Good afternoon, Denise Mosley. For the record, persons wishing to provide public comment remotely may access the meeting by using the telephone number and meeting ID posted on the agenda. Public comment will be limited to 3 minutes per person, and comments based on viewpoint will not be restricted. The chairman may allow additional time to be given to a speaker as time allows at his sole discretion. NRS 241.020, NRS 241.030. Is there anyone in Las Vegas who would like to make public comment?
Mary Ann Widener for the record. I just want to let the board know and the department, just thankful so much for how everything was handled this year with regards to the materials and the timing of things. I think the department has just done an incredible job of putting together materials and making them available, and the record was clean this year. We had a few minor hiccups, but everything was resolved rather quickly. So I just wanted to say thank you for that. And I would ask that the board would just grant Clark County some understanding that we understand there's going to be some new formatting here going forward, but we're doing our best to adjust to what the board is looking to do. And we understand you're trying to stay organized and keep the record clean, and we want that as well. So thank you so much.
Is there anyone else in Las Vegas wanting to make public comment? Is there anyone via Zoom that would like to make public comment? We do not have any more public comment, Chairman.
Thank you. I think that concludes our agenda for today. So I think we stand adjourned.
We do.
Thank you. And I will just echo Mary Ann's comments. I think you all have done a great job getting the materials going and getting them on. Yeah, I think we're running smoothly.
Thank you, Chair. We really appreciate that. And the positive comments there go to my team. They do an outstanding job.